CRLMC 87 VC and 2527 were answered, my lord. Hence,
in the past. ठीक है, दे दियो. Order has already been passed since long. Why it has been indicated? The fine has been stayed. Paper book. Thereafter.
But you think over why paper book? You can take. There is there. You can take the soft copy.
Yes,
pen drive and.
Of appeals, my lord. So pen drive. So
whenever the matter is maturing for hearing, you can take it from before 1 day or 2 days, so that the paperwork is reduced.
Let them file petition for preparation of this through online. Then the
whenever there are application,
the appellants are there. Appellants will take
the case to case basis.
Yes, my dear. So let it be office may be directed to verify the paperwork. So thereafter it will be list.
87. Race is directed to verify the paperwork, and the noting in sub item is to be
maybe ignored.
Yes.
My lord, item 19, my lord.
19,
my lord.
Wait, it will come.
My lord, item 75 permitted to withdraw.
25.
My lord. Memo has already filed.
75 withdraw.
my lordship, item 73. I pray for time for next week.
Then we wait here. We'll see. 73 is revision.
73 CRLMC.
Huh?
CRLMC.
Okay. After notice or fresh matter?
It's for order,
Fresh
but
matter?
there's a defect.
Item number 108. Adjournment, paper adjournment.
Revision.
Division.
It will be there on the board. If it comes, then we'll see. We'll accommodate you.
Okay.
Item number, lordship, 96, lordship. I pray for one
Revision.
criminals, not revision, lordship. CRLMC, lordship.
After notice, with the other side, you see. Bring the other side, Lord. Mark
Other side is state, lordship.
and interim order is there.
Yes, lordship.
Why are you asking for this?
Sought adjournment, lordship.
Why?
Some instruction, needs some instruction, lordship. That's it.
Sorted them.
And lordship, 111, that is 2012 matter. So that is also.
Revision.
Yes,
It
lordship.
will be there on the board with you.
Yes.
Item 117.
It is revision. It will be there on the board. Don't worry.
96 Obliged, lordship.
Yes, sir. Some mentioning.
My lord.
Council, sir. Yes, Mr. Kanungo, are you mentioning anything? Mentioning. Yes, Mr. Kanungo, are you mentioning? क्या हो रहा भाई? Sound? Mr. Patrov?
Yes, ma'am. Your Lordship, I filed a CRLMC 4457 and 2244 in 2023. Sir, gotte thara bhi hamara ye hearing he parni. Mu bahut mention kali sir eta asuni.
Give memo, we will see. Give the memo, huh? We'll see. Yes, Mr. Kanungo. Yes, see, Mr. Kanungo, you wanted to mention, huh? They said he has kept it. No? He is unmute. He has to unmute. What to do?
Adam to mention my
Yes, yes, Mr. Kanungo, can you hear me?
Am I audible, my lord?
Yes, now you are audible. Yes,
It's not audible, my lord.
yes.
Everything has been muted.
Yes. Tell me. Yes, you want to mention something.
Am I audible?
Yes.
But settu voice asu. Sir, settu voice asuni. So I'll mention it later on.
ଏପଟୁ ଯାଉଛି ଆପଣ ପଟେ ଆସୁନି
नहीं नहीं मैं put जाऊंगी put जाऊँ
ଏପଟୁ ଯାଉନି
anyway we'll mention it later. Come on.
item 1
Well, pardon to mention, item 72, I prefer adjournment.
72.
72.
Is it-
And no intermediate is there. Pardon,
You like the agenda.
pardon, Your Lordship, I already filed a memo, Your Lordship, by the release of vehicle, the fresh matter, fresh CLMC, Your Lordship.
Yes.
item 1
May I please?
again
Sir.
In the petitioner, was working as an assistant teacher, Millard.
Hmm?
Was working as assistant teacher, Millard.
Hmm.
Now he retired as a headmaster, Millard. Allegation against him that I told if I have given annex 1 page 10.
Hmm.
Allegation of 409. The running page, page 12. That amount of rupees 1,30,000 was disbursed to him, Millard, for the purpose of construction, Millard, for the development of the school. He could not utilize that amount, and the entire amount of 1,30,000 has been recovered from the petitioner. I have annexed the seizure list,
Recovered.
Yes,
Recovered by seizure or you
by seizure,
then
by
the crime is committed.
No, entire in fact, he could not utilize the amount, and police has seized some amount from him, and also the last annexation, that is annexation 6, the district project coordinator wrote a letter to the DI of schools, annexation 6 page 36,
Yes.
the column number A, works executed by C. Ponda in utilization of rupees 28,000 so and so was also substantiated in the measurement taken by the technical consultant Athagot, and 12,000.
If it is seized, then your offense remains.
Why, the entire amount which has been given to him, for the purpose of school, the amount could not be utilized, and some amount was.
You tell me whether any recovery proceeding was initiated. On the basis of that recovery proceeding, the money is recovered from you.
That have
No, FIR was registered. No, FIR was registered. It is there, apparent looking.
Yes, my lord.
FIR was registered.
Yes, my lord.
Part of the money you have given, part of the money is seized from you
Yes, my
by
lord.
the police. Then,
he has not
No,
given
and
anything, my lord.
this is not a stage where it can be.
My-
He lost him, can say the charge sheet page, the running page 23, my lord.
Charge has been framed.
And the matter has been stayed, my lord. The proceeding has been
15
stayed.
minutes that is dead.
Right now, let counsel for the petitioner seeks to withdraw this petition to raise all these points at the stage of framing of charges before the trial court. With this liberty, the petition is disposed of. You argue all these points.
Yes.
Item 2
My please, Your Lordships. Petitioner seeks to assign the order of cognizance, Your Lordships, order dated 9/1/2020.
Yes.
The petitioner's husband has alleged to have been involved in a disproportionate assets case, Your Lordships. An initial FIR, which is annexation number 1, was lodged against him.
You are
Device.
prosecuted under date of 109.
No. 34, Your Lordships.
34.
34. Your Lordships, I am also working as an assistant government assistant teacher, government high school at Hirakud. So, there is no such allegation per se against me. Initial FIR, it may be against my husband. I'm not on that. But then I have been attributed at a later stage. The assets, and on the basis on which assets I have been shown to be connected, the same assets have been put through across to against my husband as well. And since I am a teacher as well, my assets should have been calculated per se. But no, they have put.
Then you have your own defense.
Yes.
Then it has to be. See, I have passed a judgment.
Yes, Lordships, I have it in fact. I have
That judgment. There, what was the case is,
She was not working.
she was not working and she is not putting forth any defense.
Lordships.
She says everything is my husband. So the husband has to prove.
Lordships.
But the moment you try to defend, put forth your own defense, then that defense has to be tasted in the trial. That is the ratio.
Then I'll.
Since you are putting forth the defense,
I understand.
so that defense you have to establish in the
I'm
trial.
getting your Lordship.
But in that case, she is
was
not putting any
working.
defense.
That was the only.
That is the only test.
Yes, Your Lordship.
And moreover, that asset was not there.
Maybe,
ma'am.
suppose the wife says that nothing is mine, it is only husband, then
Husband,
husband has to prove,
Lordship,
because she is not putting forth any defense,
Lordships.
per se.
Then I'll examine a little bit further if possible.
That is better.
And your lordship kindly see, he has challenged the order of cognizance dated 9/1/2020,
Lordships.
and by this time,
No,
much
the-
water.
Anyway,
Trial
she
is not-
wants to,
I took
See,
sought for an adjournment last occasion. The trial is not progressed at all.
anyway, you research if you
Lordships, I
can
will.
help that lady, we can very well
Lordships.
do it on the basis of law.
Lordships, will.
But this ratio will not,
I add.
yes.
Item 3.
Lordships.
My lord, item 3, I prefer an adjournment as my learned senior is not there.
Why can't you argue?
File is not with me, your lordship.
Without file, why have you come to the court? You should have come the
My
file.
apologies, your
File should be
lordship.
there at least with you. At least if the court asks you what is the facts of the case, how will you
Pardon me,
answer?
pardon me, ma'am.
Never ask like this. At least you should hold your file. You never know. The court may say that no, nothing doing. You argue then. Okay, adjourn.
Item 4.
Lordship, on behalf of Mr. B.R. Dole, I kindly prefer an adjournment.
You have the same problem without file. Adjourn.
Item
No,
3.
is there an interim order? 1 minute.
Sorry.
Interim order is there, then I.
No, madam. Simply adjourn.
Interim order is there, either I'll vacate or I'll impose cost. Then only yes, adjourn, no interim. Yes,
Item 6.
May I please, your lordship?
yes.
My lord, the petitioners, lord, four.
Five.
Sorry, my lord. Next matter is mine.
Okay, so,
May I please, your lordship?
yes.
My lord, here the petitioner challenging the entire proceeding. Your lordship may kindly see, charge sheet I have been filed as per the order of this honorable court. Absolutely, there is no allegation against the present petitioner. No prima facie case made out against the present petitioner. None of the ingredient of the any offences made out against the present. Your lordship may kindly see the entire case arising out of a complaint case.
You are Vishal Pradhan.
Yes, my lord.
Here.
Entire case arising out of a complaint case. That complaint case has been filed against one Subhas Naik, not the present petitioner. The name of the present petitioner is not found in the complaint case as well as in the statement of the all the witnesses, and all the witnesses category stated that the Subhas Chandra Naik has received the second hand motor. The allegation against the present petitioner is that only 3 witnesses stated that vehicle kept up.
Just now you said there is no allegation.
No allegation, no allegation. Only vehicle kept. No allegation of offences. That is, so far as the kept vehicle is gonna, absolutely no seizure has been made out by the investigating officer. Your lordship see entire proceeding. Charge sheet I have been filed. The charge sheet stated that the Subhas has not paid single installment to the finance company, and the Subhas Naik played hide and seek with the complainant.
Ranjan Behra had
Yes.
handed over the misappropriated car to
Yes.
one Vishal Pradhan.
Yes.
The
Only I have received the
photographs
car.
of the second hand car.
Yes.
Showroom and so and so.
No offense, sir. 420-406-47, nothing.
See, something is there, some allegation is there.
Absolutely, the complainant does not know the Vishal Pradhan. Who is the Vishal Pradhan? Nothing. ମତେ ଗୋଟେ କାର ଆଣି ଜଣେ ଦେଲା, ମୁଁ କିଣିଲି ତାକୁ, ବାସ୍ ସେତିକି ମୁଁ ରଖିଛି।
You are absconding.
No absconding.
Preliminary charge sheet 420 against the.
Yes, 420. Thereafter, final charge 406, 470, other offences attached. Nothing. No car has been seized from my possession.
Now let us see the.
Yes.
charge sheet.
What happened in this case, my lord?
Hmm.
The complainant, my lord, purchased the car from the my lord, the loan and taking loan, my lord.
Hmm.
Thereafter, my lord, during COVID period, my lord, he wanted to sell that car, my lord. By the time the main accused who's against the complainant lodged, my lord, namely Subhas Naik, my lord. Subhas Naik taken the car, and with condition he will repay the installment amount to the finance company, my lord. And by the time, my lord, what happened, they had taken rupees 6,50,800, 183, my lord. You should check that decision, my lord. Thereafter, what happened, this petition, present petition, Vishal, my lord, Pradhan, my lord, read out. On the interrogation of Subhash Naik, he confessed that he had taken possession of a car from Sukumar Mandal, who is the initial, my lord, the owner of the vehicle. On basis of above noted agreement by the assurance from the Banbihari Swai and Manoranjan Swai to
Subhash Naik.
fulfill the
Not the person.
condition noted agreement. But on further interrogation, it came to light that Banbihari Swai and Manoranjan Swai had handed over the car to Ranjan Behra. Then Ranjan Behra had handed over the misappropriated car to one Vishal Pradhan, the owner of a Gaurava Motors and second-hand car showroom at Dolamundai, Chak, who was in the judicial custody GMFC Royal Kotak as accused persons was judicial custody GMFC Kotak. He has remanded in this case, my lord, and a remand order sent, my lord. He has remanded case.
You are
car
the
question with this
second hand car
he is having sold,
Yes.
my lord.
and
I am
the car
received.
which has been used to commit the
Madam.
crime, that is ultimately found in your second hand car.
Only I am received the car as
The
a,
only is the only offense.
That is
That's-
the allegation.
that is
That
nothing.
is the matter. He has even
Received from the neither on the principal accused nor on the.
Where is the car? You
Car-
might have sold it to someone because you are
But that
second hand
is
car
the
dealer.
That has not been seen my nothing.
could-
Car has been the some other person.
Where is that car? Has it been
Nah.
recovered?
No recovered
That's
from
the
my.
problem. If the
For
car
that
is not
reason,
recovered, check is given, that is dishonor.
And this Vishal Pradhan could not be interrogated as because he was in custody in Kujang jail
Not-
and he has remanded in this case.
That's
my
why
lord.
charge sheet
And
has been
other
filed.
420 case, my lord.
Your lordship may
No, but
kindly
this
see
is not
entire
filed.
allegation in the charge sheet, nothing, no allegation actually.
You were involved in some other case also.
My lord, 420 case.
Some other cases.
Same
Not-
kind of
Same 420
second hand
case.
car.
For 21.
Second hand car.
Huh.
Come and tell the criminal court.
My lord, it is
See,
actually,
file a suit,
actually,
let the suit court
your-
try it.
your lordship is absolutely, it is their father who set up approach the civil court regarding his.
I don't know. This is
Your lordship may kindly see the adoption deed annexure 3. It is of the year 64.
all these things has to be tasted in it.
My lord.
I am not conducting a trial.
Nay,
These are the
my lord, my lord.
dispute, these are the factual dispute, and this went through a judicial scrutiny up to Supreme Court. Supreme Court said we are not going to say anything insofar as the community status is concerned. However, since the education qualification is acquired by you by your own efforts, we are protecting that.
My lord.
That's what the Supreme Court
My
said.
lord.
So, insofar as community status is concerned, it has to be tested somewhere. Is this the proceeding where I can test it? Answer is no.
My lord. But with great respect, my lord, what are the fault of the present
I
petitioner?
don't-
Because of their father, my lord,
I don't
he
know,
got
maybe-
them admitted.
Maybe you are correct.
Therefore, they were also fair enough before this honorable court also that it is our father who got us admitted.
Maybe you
And we are supreme, we are married, my lord, serving elsewhere. Now a general category, my lord, we have been successful to get
when
jobs.
the FIR was lost,
2008, my lord.
I can expedite the trial.
Well,
That's the only relief I can give.
just
because
point at the
208
time of framing,
the
sir.
unnecessary suffering. And you went up to Supreme Court, so many things happened. I'll expedite it and give you liberty to raise all these points before.
At the time of,
Whatever.
my lord, my lord.
Then counsel for petitioner seeks to withdraw this petition, reserving his right to urge all the points before the court below at the appropriate stage. And he further submits that the FIR was lodged in the year 2008, and he has undergone the proceeding for such a long period. Therefore, he wishes to expedite the trial, pending trial. Taking into consideration the fact that the petitioner has suffered the proceeding since 2008, and he had also challenged his termination from the service before the court, before this court, as well as before Honorable Supreme Court. I am of the considered view that the trial court should do well to see that the trial is expedited and preferably and disposed of preferably within a period of How much? How many witnesses are there?
No, there are many witnesses, my lord.
Charge sheet, very charge sheet. Yes, how many witnesses are there?
Before December 2024, your lordship.
1 minute. How many?
There are, my lord, 28 witnesses.
Also, then it will take time, no?
Time, my lord.
About 6 months. Huh? Six.
Grateful, my lord. My lord, your lordship may say the petitioners. There are 4 petitioners, your
Petitioners.
lordship. They are the all sons and daughters
Okay.
of. Grateful, my lord.
Item 9.
May I please, my lord, on behalf of Mr. S.K. Dwivedi, kindly 2 week after.
Adjourn.
Oblige, my lord.
Item 10.
My lord, 1 week after, my lord.
Hmm?
1 week after, my lord.
Adjourn.
Item 11.
Who adjourn what would have July what are you?
Item 11.
What is that? Display. What is this? What is this, Mr.?
My lord, compromise matter, my lord. Pass out. Yes.
Compromise pass out. Yes,
Item 12.
My lord, pass over this matter.
pass out.
Item 13.
Item 11, my lord.
Yes, what happened? 11?
Compromise.
Parties are there.
But no, first time as change.
Bring the parties, adjourn.
Are there na?
My lord, stay further proceeding, my lord.
No, second week I am keeping it.
Compromise.
Yes. 13, huh?
13.
May I please, your lordship.
Yes.
But the order challenging issuance of NW at Annex 2, my lord, page 14. But it arises out of a complaint case, my lord. But offense on section 138 of the NI Act, amount is 60,000 rupees.
Who are you? Accused?
Accused, my lord.
Hmm.
But the accused appeared and thereafter for wrong posting of date, he could not appear on the date. But page 14, your lordship, kindly see the at the first instance the NW was issued. My lord.
Okay, fine. NVW. In this petitioner is assailing the order dated 10/1/2023, whereby the court below as 10, huh? What is that?
10/1/23, my lord.
Where is there? No, controversy. Complaint is present, the option next to be taken. Okay. The present case is arising out of when complaint under section 138 NIA, and the petitioner is the accused. On 10/1/2023, due to the absence of the petitioner, the court below issued NBW. On instruction, petitioner submits that he would be appearing before the court on or before 30th of May, and seek remedy available to him under law. Taking into consideration of fact, the order dated 10/1/2023 passed by SDJM Bhavani Patna in ICC case number 61 of 2020. Is kept in abeyance, execution of order kept in abeyance, subject to petitioner appearing before the court on or before 30th of May, and apply subject to so speak. Okay. Allowed.
Obliged.
Yes.
14.
14 minutes, may please. 14 minutes, I'm challenging the rejection of my petition for export opinion, my lord. The improved order is page number 19, my lord. By learned.
What export?
My lord, it's a matter under 138 of NI Act, my lord. The complainant alleged that a check of ₹10 lakh has been degenerate by due to insufficient of funds. But my standard is that those are not never even issued by myself. Those some blank checks have been given for the purpose of security. We were 2 friends and we were doing coal business, my lord. For the security purpose, I supplied some blank checks.
Are you denying the signature?
Yes, that's why I'm filed a petition for
You
export.
say you are giving on security.
But I have never been signed on that part on any.
You said security you have given.
But
Where is
I,
your application, show me?
that application is on page number,
If you have given security, you are not denying the signature.
uh,
In the
that annexure.
check, if you have a signature, the other, see, suppose
no.
I'm signing a check.
No,
My staff has filled up the check.
no,
And I only sign it.
no, only blank text.
Likewise,
Though I have signed only blank. No, never any amount has been put on there.
That's right. You never know. So therefore, where is the question of sensitivity?
That is my page annexure to page,
If you have signed the check, then presumption operates against you. And there are many ways
No,
to.
no, I don't dispute that. I signed that check, but I have never put any amount, my lord. For security purpose, I have given only. That's why I filed a petition for expert opinion, though it is a corroborative.
Expert opinion will say what will
The ink, the age of the ink. I mean, unless the opinion expert on age of ink and handwriting for the payee name, amount in words and figure, mention date with other possibility exhibited documents as given by this honorable court for compare.
check amount?
10 lakhs, my lord.
Why have you given security?
Oh, for that we are partner and we're doing coal business.
Settle. Give the money and settle.
I'm
not going to allow this, but
at least they consider.
Simply I am issuing notice to see the matter can be settled out.
Well, let's for a moment. I just need to submit
There is
two lines.
No question. I am issuing notice. Simply I am issuing notice to explore the possibility of settlement, but I am making it clear that I am not going to allow your application. In these kind of cases, no question of expert service.
Till further that
No.
day of the further proceeding.
I am issuing notice reluctantly, only to see that it can be adopted.
Only a sort. Then your lordship may sort that maybe fix.
No, he will give it. Date will give. No problem.
Deeply obliged.
Opposite matter 2 months.
Issue notice opposite party.
2. Item 15.
Obliged.
Businessman, you are businessman, you don't know how you have signed the check.
No, I
Don't tell all this technicality. You are the partners, you know why you have given the check.
My stand is that I have not put any amount.
Not necessary. I gave you example. If I am issuing a check, suppose I'll tell my staff to fill it up. He fills up and I sign it and give it. So handwriting will be different only. But I owe the responsibility because I signed it. If you send it to expert, he will definitely say the signature and the entry made in these things are different. That will lead you nowhere.
No. My signature means for the amount, the kind of ink and the date. That may be.
No. You don't have a case. Come with the check, money and pay. I will persuade the other side to fix some installment and that's the only thing. Yes.
May I please, file the present application for quashing of the inter proceeding on the ground of compromise, my lord.
What are the offences? Complaint case.
My lord, running out of complaint case.
Where are they?
My lord, here.
What are the offence?
Alleged offence is on section 366, 376, 506, 34 IPC, my lord.
In
My
a
lord.
complaint case.
My lord.
You have not filed. They have not filed FIR also.
No, my lord. No. In the meantime, they married to each other, my lord. Blessed with two child.
Who married? The
accused.
opposite party number
3.
3 married to
Petitioner, my lords.
Okay.
Blessed with
My lord, this is the affidavit.
petition. Check, sir. Complainant.
Name of accused person. Please. Complaint.
Complaint.
Does.
Complaint. Production officer there.
Madam, at the instance of opposite party number 2, ICC case number 2 of 2005, was filed by the against the petitioner, inter alia, alleging that on 2/1/2005 at about 9 a.m., 9 p.m., the daughter of the opposite party number 2, namely Kumari Santa Pradhan, bracket opposite party number 3, went to her uncle's house in the same building. Full sir. It is alleged that the accused persons had kidnapped her. Kidnap her so as to get her married to the petitioner number 1. Subsequently, the informant also came to know that petitioner number 1 and his daughter have already married and staying together. Full stop.
Now they blessed two children.
The parties are present before this court. The petitioner and the opposite party number 2 and 3 are present in the court. The opposite party number 2 and 3 states that the opposite party number 3 had already married to petitioner number 1 and they are blessed with a child.
Three.
Huh?
Three children.
Three children.
I would have
Blessed
taken
with
that.
three children. Three children. Therefore, they state that they don't want to proceed against the petitioner, proceed against the petitioner. Full stop. On the basis of the settlement, the parties have filed the petitioners have filed the present petition seeking the watching of the entire proceeding initiated against them. All the petitions are present.
Petitioner and opposite party number 2 and 3, my lord.
Present.
All the present.
The petitioners and opposite party number 2 and 3 are present and being represented by their respective counsel and identified by them. They have filed the self-attested copies of their Aadhaar card to establish their identity, which are taken into record. Next one. The petitioner number 1.
Only petition.
Only petition.
Only.
My lord.
Only, yeah. Petition number 1, like, only petition. Like, okay, right now. The parties have filed a joint affidavit dated 24/4/2024 inter alia, stating that in view of the fact that they have a in view of the fact that the petitioner has already married to the opposite party number 3 and blessed with 2 children. Not 3. The 2 children, with 2 children and leading happy marriage. Today only they are giving the affidavit. Why have you written 2? You don't know what you are writing in the Write down 3.
I am correcting.
Sign it here. You have written initial code. Then 3 children. 3 children. Therefore, the complaint is filed by the opposite party who against the petitioner shall not be prosecuted. Mr. Ragada, please participate and submit that the dispute that the case is arising out of a complaint filed by opposite party number 2. This is the matter has already been settled. The petitioner has already married with the opposite party number 3 and placed with 3 children. Therefore, in the particular facts of the present case, this court can give indulgence. ज्ञान सिंह देगी ठीक है चलो डेफिनेटली टेकन ऑर्डर चलो नेक्स्ट
Hopeless man.
Me please.
yes still
Compromise matter, my lord.
Hmm.
Annexed to mother of the victim and the informant file in affidavit before the Lord Trial Court. Baleswar, my lord.
Where are they?
Annexed to.
Where are they? They have come. Bring them. Second week.
Yes, my lord.
Bring them. Yes.
Item 17.
Last occasion, Lordship directed to file a notice to the opposite party. We have already supplied notice.
Message already settled. Where
We informed the opposite party number 2 and by way of we have filed the registry board. Okay. So inform they were not collecting the only Lordship have taken on next week. So,
first week of the first week settlement. Settlement. Yes.
obliged to Lordship.
18.
May I please, your lordship may permit me in VC mode, man.
Yes.
My lord may kindly turn to page 72.
70?
72, my lord.
Yes. Yes.
My lord, 125 proceeding was initiated in by the wife. In the interim, it was directed 6,000 to the wife and 4,000 to the child. This is not questioned by me. I don't question that. That
What
was
is that?
allowed. That was
Which one? Which one? 72. Yes.
page 72.
Directed
My lord,
6,000. 6,000.
6,000 to the wife and 4,000 to the child. My lord, I
Yes.
don't challenge this order. I don't challenge this order. Finally, it was directed, your lordship will kindly turn to page
This was
46.
the
That,
page
that was
72
interim,
interim.
interim maintenance.
Yes. Now,
Now, in the final 125, it was directed that you pay 10,000 and 4,000, total 14,000.
hmm,
Page 46.
46.
Six.
Yes.
My lord, I'm not agreed by that order. I accept it. Now, when the execution case is filed, the entire 14,000 is put to execution. I filed a petition that the amount which was given in the interim maintenance may be deducted and the account may be squared up and installment may be granted. That is also refused by the court below, and NBW has been issued. When a bailable warrant has to be issued first, then only NBW is to be issued. My lord, I am ready to pay the money. I don't say that I will not pay the money. But that
What is the
interim,
due? What is the due now? Arrears?
my lord, if it is deducted, it will be around 3 to 4 lakhs, my lord. I am ready to deposit 1 lakh within 15 days. Let notice go, let them come. This amount may be, interim may be squared up and I will clear the amount. I don't dispute it.
Your case is the interim maintenance, whatever you have given.
Yes.
That should be
Adjusted.
Adjusted with the final this thing.
Yes. Yes.
That's always there. What is the problem?
Yes, but they have put the entire 14,000 to execution and they have assessed that it is around 10 lakhs. My lord, the interim maintenance 5 to 6 lakhs I have already paid, my lord. That is to be adjusted. I filed a petition that.
Right down. Wide order dated 72, no? Wide order dated order dated 22/10/2021. The SDJM Reichhold in CMC number 21 of 2016 passed an interim maintenance order interim maintenance order of 6,000 and 6,000 to the wife and 4,000 to the child. 4,000 to child. Child. The petitioner has been paying the same amount without any objection. When the wide impugn order dated 46, wide impugn order dated what is
12th April 23.
12th April 23. The the
Final maintenance was passed.
the application under section 125 CRPC moved by the opposite parties have been finally allowed, and the interim maintenance order has been modified to the extent that 10,000 shall be paid to the petitioner number 10,000 shall be paid to the opposite party number 1, and 4,000 to be paid to the opposite party number 2. Mr. Bose, legal counsel for the petitioner, submits that even he doesn't have any objection insofar as doesn't have any grievance insofar as the said order is concerned. Next part. When the opposite parties subjected the aforementioned order for execution. In the execution petition, the petitioner inter alia contended that the amount he has already paid in compliance to the interim direction shall be factored into the factored into the areas demanded by the opposite party. However, it is contended that the court below is insisting to pay the entire amount on by calculating 14,000 rupees per month without factoring into the amount he has already paid as an interim maintenance. Next person. Issue notice to the opposite parties subject to petitioner depositing 1 lakh rupees. 1 lakh rupees towards the areas of rent without prejudice to the right and contention of opposite parties, and also subject to the condition that the petitioner shall keep on paying the awarded maintenance up to date,
Yes, ma'am.
awarded maintenance every month as directed
Yes.
by the court bill. Leave the matter.
My lord, I have filed a miscase of staying further proceeding in criminal miscase number 46 of 23. I'll deposit 1 lakh. I'll deposit 1 lakh within 15 days. The
And
further
you
proceeding-
you keep on paying the maintenance every month.
Yes, my lord. 14,000 I'll keep on paying. No issue on that.
Okay. The execution proceeding.
Criminal miscase number 46 of 23.
Criminal miscase. The further proceeding in criminal miscase number 46 of 24. 46 of
23,
24.
my lord. 23, my lord.
Is state subject to the condition as aforementioned. Yes.
Criminal miscase number 46 of 23.
You deposit 1 lakh without
Yes.
prejudice.
My
And
lord,
keep
within
on paying.
15, your lordship may say within 15 days I'll deposit.
15 days. And keep on paying monthly maintenance.
Yes, my lord. 14,000 I'll keep on paying. My lord, that miscase, criminal miscase number is 46 of 23 pending in the court of SDGM Rerakol.
Yes. Next.
19, my lord, pray for next week the conducting council is ill, my lord.
Adjourn.
Oh, please.
20. May I please, your lordship. Your lordship, annexure 1 is under challenge, my lord. Annexure 1 is a DB proceeding initiated by the opposite party, my lord, who is sister, against her brother for maintenance, your lordship, maintenance of 27,000 rupees, your lordship.
Yes.
My point of challenge is that she is not entitled for maintenance, since this proceeding is not maintainable, because sister is not entitled for maintenance, your lordship. Sister is not entitled for maintenance from brother, your lordship.
Gunanidhi Sagar is the
brother of opposite party, my
of
lord.
Kalpana Sagar.
Yes, my lord.
She is initiated under what?
A DVA proceeding, section 12 of DVA, lordship. Annexure 1 and annexure 2 is the petition, my lord.
She is unmarried sister.
Yes, my lord, unmarried.
Unmarried sister. You are the elder brother.
Yes, my lord.
Divi.
Section 3, your lordship, if your lordship will see, section 3 of 3 IV, my lord, the proceeding. That's the economic abuse.
She
Includes,
is married and staying with you only.
my lord. No, she is not staying with me.
The address is same.
Yes,
Mandalia, same address, same house. You have written in your own college.
but they are separated, my lord. Maybe the village is same, but they are living separately.
He is
The
saying
se-
he is entitled.
But maintenance is, I mean,
Protection of. Yes. Section.
section 3(4), my lord. 3 IV, the Roman 4. Economic abuse, my lord,
What are
include.
you doing?
I'm an employee of MCL, my lord.
MCL.
MCL, yes.
What are you doing? MCL what? MCL.
Yes, clerical staff, my lord.
Section 3, huh?
Section 3, my lord. Economic abuse includes deprivation of all or any economic,
Definition of domestic violence, huh?
my lord. PWDB Act, my lord.
Yes.
Economic abuse includes deprivation of
Which
all.
one? Section 3 definition.
My lord.
Hmm.
Definition that for the purpose of this act, any act, omission or commission or conduct of the respondent shall constitute domestic violence in case it. My lord, the relevant portion is the 4. The clause 4, my lord, that is the economic abuse, my lord, because her claim is maintenance, my lord, or 27,000 rupees from the brother. Their lordship, it includes deprivation of all or any economic or financial resources to which the aggrieved person is entitled under any law or custom which are payable under any order of court or otherwise, my lord. That is the point. I mean, sister is not entitled for maintenance, my lord.
All or any economy of or finance resources to which the aggrieved person is entitled under law, any law or custom, whether payable under an order of the court or otherwise,
Sister.
which the aggrieved person requires
Yes.
out of necessity, including but not limited to. No, you read the entire A.
My lord,
Read
yes.
A.
A.
4A.
4A, my lord, yes.
Economy abuses includes.
Yes, my lord.
Write down, read it. Deprivation of all
or any
of economy or financial resources, customs,
my lord.
whether payable under an order of the court or otherwise,
My lord.
or which the aggrieved person requires out of the necessity, including and but not limited to the household necessity for aggrieved person. If you come to aggrieved person, who is aggrieved person?
Aggrieved person is the
Come to the definition.
the siege aggrieved person, my lord. If siege a woman,
Maintain it.
my lord.
He can maintain.
No, my lord. Yes, there is a domestic relationship, but she has to entitle for maintenance, my lord.
He is entitled because see, it is very wide.
My lord.
All or any economy,
Yes, my
or
lord.
financial resources.
Definitely, my lord.
which
Definitely, but
the
siege.
aggrieved person is entitled to under law
My lord.
or customs.
Yes, my lord.
It is so wide.
Yes, but she has not mentioned anything that she is entitled for entitled under any custom or law. She is simply claiming that she is entitled for maintenance under DB Act, my lord.
You don't go by pleading. See, your sister staying with you and unmarried sister, you are working. So she is an agreed person. Where is your application? What have you moved the application?
Sorry, my lord.
Where is your application?
The court below, my lord.
You go and move application. Satisfy the court that is maintainable or not. Why have you straight away come here?
No, my lord. I have this has proceeded, my lord. This particular case has proceeded.
I know, but
My
you have to move application saying that it is not maintainable. Satisfy that court.
But this is per se not maintainable because on law because
It
she's
is
not
maintainable.
entitled.
According to me, it is maintainable. Just see reading. It is so wider.
But she has to satisfy the court that she is entitled
Which
under
court?
any law, my lord. Any court, my lord. If she is going to the magistrate.
You have to satisfy now.
My lord, I will definitely. But thing is that I don't find any piece of legislation or any judgment where it says that sister is entitled for maintenance, my lord.
Sir, the expression used is or, not and.
Yes, my lord.
So
Yes.
it is so wider now. Custom, whether payable under an order of a court
No, my lord.
or otherwise.
No. First thing is
which an agreed person requires out of necessity.
Yes, my lord. The first
If
thing
he
is that
agreed
there has
person,
to be.
you say she is an agreed person.
She can be
requires
agreed
for her
person.
necessity.
No, my lord. She can be an aggrieved person if she will come under the definition if she's a female and there is a domestic relationship. Domestic relationship cannot be ruled out because she's a sister, my lord. That is one thing. But thing is that she has to satisfy either of the one. First is the law or custom, my lord.
No.
Then only if
No.
yes, my lord.
Custom and thereafter read further.
Yes, my lord.
All or.
Whether
Everything
payable
or.
under any, my lord, sorry.
Read
to
it.
who is the aggrieved person is entitled under any law or customs.
Nah.
Then, my lord,
Whether
if he is
this-
entitled,
this-
then by the order of the court or
Custom-
otherwise.
Custom means how will you define custom?
Custom depending upon the
Unmarried sister staying with the brother is customarily you have to.
No, my lord. Custom has to be a definite custom and it has to be proved, my lord.
Again, it's so wide. I don't know.
I mean, she has not taken any pleading that she is governed under she is coming from a tribal community, my lord, and she is entitled for maintenance under a custom, my lord. It is not pleaded or nothing is there. Only she has to show that she is entitled for maintenance under any law, my lord.
Have you moved any application before trial court?
I have rejected, my lord. I have filed one that annexure 3, your lordship. There I have refuted, my lord. Annexure 3, page number 38. Annexure 3, page number 38. Paragraph number that a case against the respondent is not maintainable, my lord.
Where is that? 3.8.
38, annexure 3, my lord. Paragraph number 1. That is not maintainable. That I have pleaded, my lord. There. I have
saying maintainable will not. One line. This thing you have seen.
Because she is not entitled, my lord. If
we'll see. We'll issue notice. Issue notice. Yes.
Lord, I have filed an IA, my lord.
A notice on IA also.
Because
these are maintenance things. Somebody's life.
But that I understand, my lord.
Unmarried, she is your own sister. How will she survive?
Out of obligation, out of love and affection, I can give. But legally, I am not.
Neither you have love nor affection. Therefore, you are coming to the court.
But your lordship, she is disputing. That's the reason, my lord. Not,
Anyway, you.
but legally, she is not.
I'll just explore the possibility. Let us understand what exactly she wants. What is her status?
But at least next state stay may be granted, my lord.
Nothing is going to happen. No, he is not going to pass any, adverse order against you. There will be a maintenance order only, some 1,000 rupees.
My lord.
Anyway.
21.
21.
May I please, your lordship? Lordship, it's compromise matter, lordship, and we filed the compromise affidavit in annexure 1, lordship.
Where are they?
Lordship?
Where are they?
No, lordship.
Bring them.
My learner friend is applying for
Bring them. Bring them. Second week. Bring them.
next week, lordship. Lordship.
Next week?
Yes, lord.
Next week. Second.
Lordship, I have a prayer, lordship. Lordship, the petition number 5 is out of state, lordship. So
How many petitions are there?
7 petition, lordship.
If all of them are appearing except 1, 2, we'll see. Bring them. At least the complainant has to come. The offences are under which section?
The offenses are. Lordship,
Repeat,
147.
307. Injury? Simple or grievous or what?
No, lordship. Simple injury. They are the family, lordship.
What is the injury I'm asking?
Injury, but I don't have. Lordship.
Family doesn't mean that you keep on attacking it.
No, lordship.
You see, you have to see the nature of injury.
Injury relation.
Lordship, on the next date, I will.
Get the nature of injury also. We'll have to see the injury.
Lordship, I have filed another CRLMC number which is connected to this case, lordship. That is the case number 1197 of 23, lordship. So I
Item
for your
23.
lordship to lordship.
23 items.
No, lordship. That is another
Also,
CRLMC
you
case
give
number which
corrected
is
matter.
connected to this matter.
Give it. Please the matter along with this matter along with that. Yes. Yes. Next. 22. Yes.
Here the matter has been in year-old matter, matter of 2007, matter has been amicably settled.
Parties are there.
Yes, ma'am. They are.
Yes. What are the offenses?
307, ma'am.
Show me the injury.
But the injury that
Report that.
Show me the injury. Who is the victim? Who is the
Injured. Aravinda.
Aurobindo Srichandan. He is the informant also.
No, your lordship may see that FIR is that annexure
You tell me who is the informant, who is the victim?
Aravind,
Aurobindo is the victim.
Yes, my lord.
Who is the informant?
Aurobindo is the informant. Aurobindo is the informant and victim, my lord.
That's what I'm asking.
Yes,
Why
my lord. Your lordship may see that, Lord, in the charge sheet, they have police has given that the informant as well as the accused, both they have stated that they are accused.
Where would you are
Not a compromise.
Don't find fault with the police. Now he'll oppose.
No. But he is the victim.
କୋଉଠି ମାଡ଼ ହେଇଥିଲା ଆପଣଙ୍କୁ? ଆଁ? Simple injury.
No, injury କିଛି ନାହିଁ।
Nice.
Injury report ଆଣିନାହାନ୍ତି। ଦେଇନାହାନ୍ତି first time।
Chalo, you see him alive now. That's enough. In many a case, what happens is the injuries are so serious and the victim is paralyzed for all time to come. On those cases, they'll come and settle. And this is very dangerous. At least he is present and all right, then we can do. Right up. At the instance of opposite party number 2, FIR number so came to be registered against the petitioner. The charge sheet was filed on 23/11/2008. Before the trial commenced.
No, my lord. Charge sheet subject showing him absconded. Thereafter, he filed petition here, my lord, and obtained stay order. And stay order, due to non-appearance, they for it to dismiss. Again, my lord,
Acha. When the charge sheet was filed on such yesterday, showing the petitioner as an abscond. Petitioner as an abscond.
Thereafter, my lord, mentioned thereafter they have filed 402 application. That is my lord, last page, Annex 4, page 23.
The petitioner subsequently filed criminal MC number 2240 of 2015, taking passing up of the entire proceeding, and eventually and obtained a interim order dated 12/8/2022. Because of the said interim order, the trial could not be proceeded. Eventually, this is dismissed in default. Eventually, the criminal miscellaneous case
dismissed for non-prosecution
was dismissed for non-prosecution on
12/8/2022.
Next one. When matters stood thus, the parties have settled their dispute. The petitioner and the opposite party number 2, who is the victim and informant in the present case, are present in the court. They are being represented by their respective counsel. The parties have now also filed a joint affidavit dated Ajit Tarkre. So inter alia stating that due to the intervention of the village gentry and well-wishers, they have settled their dispute, and opposite party number 2 is not interested to prosecute the petitioner anymore. The affidavit is taken on record. Mr. Ragada appears for the state and submits that although the FIR was registered under section 307 IPC, and charge sheet is also filed for the same offense. However, the injury received by the opposite party number 2 was simple in nature.
Lordship may mention petition counsel for the petition submitted the injury is simple in nature.
Mr. Ragada same simple in nature. Mr. Ragada jagade and counsel petitioner submits.
Yes.
Okay. Mr. Ragada submits that this is a case registered in the year 2007. 2007. Charge sheet was filed in the year 2008. The matter is not proceeding because matter has not proceeded. because of this stay order operating, because of the
Stay order
stay
and-
operating,
Now the NBW, my lord.
operating. Eventually, the court below has now issued NBW.
That has not been
against
executed.
person. At this stage, the parties have settled the dispute. Settled the dispute. Settled the dispute. Both the parties are present in the court and they have filed the affidavit before this court. Therefore, subjecting the petitioner to trial may be a futility. Right? Accordingly, the present case is covered by the judgment of the Supreme Court in Gyan Chandra. So, next, taking into consideration the aforementioned facts and keeping in view the fact that the incident had taken place in 2007 and parties have settled that issue. In my considered opinion, this case deserves merit. Accordingly, FIR and so on. Subject to petitioner paying 5,000 rupees to the opposite party number 2 and 2,000 depositing 2,000 rupees.
The High Court of Orissa
with the High Court of Bar Association. Pay it. Okay. 5,000 to pay him and 2,000 to pay him. This by the concerned authority, which has already been communicated to him. The same is placed on record through a memo. In view of the said development, the petition seeks to withdraw this petition. Disposed.
24.
Yes.
The petitioner in this application challenged the order of cognizance and NBW, but my limited prayer before to grant me liberty so that I can surrender and face the trial. The background of the case is that
No, I'll allow it.
Fine.
Why to go into the where is that NBW order?
Sorry,
NBW order.
Annexure 5 series.
5.
My lord.
The petitioner had challenged the criminal prosecution initiated against him through the against him by questioning the FIR number so on so on. Okay.
FIR Annexure 1.
He further submits that the court below has now issued NBW against him by order dated 8/1/2009. He seeks to raise
5/8/2010, my lord.
5/8?
2010. NBW order. I have annexed the entire order sheet.
Annexure?
Annexure 5 series, page 25 order sheet. Because
5/8/2010.
my lord. Thereafter
5/8/2010. The land conservation petitioner submits that he would raise all the points before the court below. However, the NBW issued against his claims may be recalled. On instruction, he submits that his client would be appearing before the court below on or before 30th of May, 2024, and move appropriate application permissible under law. Taking into consideration the aforementioned facts, and submission of the bar. The order dated, execution of order dated 5/8/2010 passed by the SDGM,
Champua. Minor.
in
GR case number 91 of 2007.
is date till 30th April. Matter is the CLMC is disposed of with the aforementioned unit.
25.
Yes. Oblation.
On behalf of Lalit Kumar Mara, kindly pass over the material.
Awesome.
26.
May please, Mel.
Yes.
Lordship, the petitioner seeks for the passing of the affair on the basis of compromise, Lordship. Say offense relating to 490 of IPC and all.
Where are they? Where are they? Bring them.
Lordship, the compromise is the space.
No, where are the parties? You have to bring the parties. before.
No. Notice may be served upon the opposite party number 2, Mel.
Press matter.
Yes, madam.
Oh, what is this annexure 2?
Annexure to Lordship is the copy of the judgment, Lordship.
Decree of
That is the judgment and the decree of the family court, Lordship. And so far as the
That gone for the petition submits that to the party to the parties have settled their dispute, and on the basis of the settlement, he seeks requirement of the FIR. He further submits that by order dated 9/9/2020, the judge family court Bhubaneswar has allowed the application of the petitioner and dissolved the marriage between the petitioner number 1 and opposite party number 2. Issue note next follow. Issue notice to opposite party number 2 written within 1 week. 1 week, and the parties are directed to present it to court. Then the next date.
Lordship may pay for the interim order, Lordship.
Yeah, next week I am giving. Bring them. Next week. Bring them. Oh, sorry.
27.
Maybe. Annexure 2, my lord, on page 7, my lord, order dated 24/4/2023, where the learned trial court has issued NBW against the present petitioner before submission of charge sheet on the prayer of IO, my lord.
You were absconding.
Yes, my lord. And
Petitioner charge sheet. When the charge sheet was filed?
charge sheet was filed on 27/4/2023.
Petitioner is accused in PS case number Saidnagar.
Yes, ma'am.
PS case number. What is this number?
City number. PS case number 86.
86. PS Saidnagar PS case number 86 of 2019. After investigation, charge sheet was filed by the filed on
27/4/2023.
showing the petitioner 27/4 showing the petitioner as abscondent. On the prayer of the IO, NBW has been issued on
24/4/2023.
24/4/2023. Yeah. On instruction and accountable petition submits that you will be appearing before the court or on behalf of service. Keep in a bench, huh? Yes, 500. Yes.
28.
May I please, Lordship?
Yes.
Petitioner filed this application for quashing of the criminal proceeding on the ground the prima facie case is not made out against the petitioner. The prosecution case is that the complainant applied an application for mutation Tahsildar before the Tahsildar Sadar Keonjhar did not mutate the land, and accordingly the appeal was filed before the higher authority, and the higher authority directed to the Tahsildar Sadar to settle the land. Again, complainant applied before the Tahsildar.
You are the Tahsildar.
No, Lordship. I am the supervisor, inspector of the Sadar Tahsil Keonjhar. The Tahsildar directed, my role is, there is no role. The Tahsildar directed.
You gave the report, Tahsildar said you gave the report on that basis. The
report, the specific direction.
Now he said that his grievance is now that I was not, that duties has not been assigned to me.
Yes.
Thing is that Lordship kindly see page 18.
80.
18.
18.
Detection report. He demanded the money. demanded the money on the ground that
Where is
on
at about 4?
one for a FR ଅଛି. Last page.
Where are you reading? 18, page 18.
18 the trap, the way of trap.
Then where
The
are you reading?
second para.
Yes.
At about 4:15 p.m. again we'll are proceeded to the Tahsil office so and so leave that 4 to 5 line relevant portion. It is found that one gentleman is after getting the money. It found that the one gentleman is sitting in a chair and complainant Sri Hari Sahu standing in the office room. Both complainant Hari Sahu and overhearing witness Senapati Jai identified the accused Harindra Sahu to the raiding team and told that little before Harindra Sahu demanded and accepted the bribe of 20 from the complainant by his right hand, counted the same in both hands and kept the bribe money in his office almirah
That is the
by
procedure.
by
That is the procedure.
But
That
it
is
was-
the
it was
that a
record from
vigilance
your project
procedure.
report.
That is not.
ପଇସା ନେଲେ ଗଣିଲେ ଆଲମିରା ରଖିଲେ ଚାବି ରଖି ଚାବି କାଢି
No, no,
ତାଙ୍କ
no,
ପାଖରେ
I
ରଖିଲେ
I'll have to quash it at the
Lord,
initial
Lordship,
stage.
kindly see the Lordship. That is the procedure. That
What
is
procedure?
not the fact of the case.
what a
That-
detection
that
report
detection
It was
report.
recovered from
The
you, man.
Lordship, kindly see the order sheet of the mutation case. Lordship, kindly see
No,
the
that
annexure
those are the matter of
45,
trial.
page
These-
45.
See, what is wrong is
There is no specific direction. That is
you have accepted money, demanded money.
no Lordship. That
Even
has
if
not been
that-
accepted. The ସେମାନେ ଆଲମିରାରେ ଥୋଇଦେଲେ।
ଥୋଇଦେଲେ
ଥୋଇ
ଚାବି
ଦେଇଛନ୍ତି।
ଥିବ ଆପଣଙ୍କ ପାଖରେ
ନା,
Set of Almira justice.
ସେଇଟା ସେ ବାଡେଇକିରି କହିଛନ୍ତି ରେ।
That will be tested.
Draft-
Trial.
both hand was positive almirah was positive.
No, the case is not made out, Lordship.
No, I can't conduct a mini trial now. Whether it is right or wrong, these are the allegations. You have
There
accepted
is
20,000 rupees.
specific direction me. That is not, I mean, case is not pending before me.
Then your lordship
Then-
kindly see the
How-
super recovery part the file concerned file from whom it was recovered page 20.
20.
On being asked about the relevant case record of the complainant, the accused Sri Sahu produced the RP case record with relevant documents. It was received from his possession. And as per said RP record, it was required for the purpose of investigation. It was seized in a separate seizure list and presence of the witnesses. And a copy of seizure list was handed over to the accused Sri Sahu on proper acknowledgement.
This letter of the vigilance department, Lordship, kindly page number
Do you
46.
want me to conduct a
46.
complete trial here?
Lordship, 46 page, Lordship, 46.
I'll see it, but there is no point.
The vigilance department letter.
Then
46,
ତାଙ୍କ document
page
ବି ଦେଖଉଛି.
46.
Your lordship kindly see annexure 6 page 45.
46,
She wants to show 46. Let us.
46, Lordship.
46 it is an internal communication.
Requested to supply of the requirement information document, the vigilance department. Number 2, Lordship, kindly see.
What is the stage
On
now?
dated 27.
Charge is to be sent. Your lordship kindly see the order sheet page 45.
Lordship, kindly see the vigilance department letter.
Your lordship got it 27/2021.
27/2001. The order sheet reveals that the revenue supervisor RI and Amin were directed to conduct the inquiry. No specific direction have issued to the revenue inspector. Please clarify. That is the letter of the vigilance department.
You argue on that. Let consider the petitioner seeks to withdraw the petition to urge all the points before the court below at appropriate stage. With this liberty, the petition is disposed of. You argue
Lo-
the charge. Yes.
Let's say the passing of the proceeding at the any stage. Let's say the kindly.
If you want, then I'll give a judgment. If you argue, and it will prejudice you in the trial. There are evidence which are there on record. So at the stage of trial, at least you can. I can't see the document which you are relying upon. These are the.
These are the documents, are the charge sheet documents.
I don't know. I don't want to conduct a trial at this stage. Authenticity of those documents, internal communication and all has to be tested in the trial. So the court which is framing charge can go into all these things. You argue there. I'm giving you that liberty. Otherwise, it should have been simply dismissed, and if you insist me, then I'll pass a judgment. And it will prejudice you unnecessary. Why unnecessary? You should not have come at this stage. You should have tried there in the trial court. At the very threshold coming to the court, 482 court, it's not required. Anyway, yes. Next.
29.
The impugn order is annexure 4.
You are accused.
I am accused, my lord.
Yes.
The case of the London JMFC directed to deposit 10% of the check amount as per the section of 143A of the fact, my lord. The sole allegation against the present petitioner, I have given check for consideration amount to sell a property, my lord. If a lordship can see for a moment, lordship, the cross examination, my lord, if lordship cross examination at page, my lord, 29, my
The
lord.
trial court will see.
Let's say that for that reason, that direction is illegal. Since there is no debt and liability, my lord, why I will deposit 10% of that amount? Let's see for a moment, my lord.
See, liability or not, that will be.
That is threshold.
The moment the complaint is entertained,
My lord,
my lord, you are liable to pay.
Then a lordship can.
And therefore, the law is you have to answer to the legal notice. Where is your legal notice answer?
That I am.
Then if you don't answer to the legal notice, you have to suffer 130.
Then when cross examination, lordship can for a moment.
You answer me where is.
That reply I have not given, my lord.
Then you suffer 139. And then 143 operates against.
Then
This is the law. I will not go into many.
Let's see for a moment. Let's see page 29.
Show me, but I am not going to.
Let's see for a moment page 29, paragraph 13, my lord.
Whatever you. Why have you not replied?
My lord.
Why have you not replied to 130? Why the statutory notice is there? It is a statutory notice, not a simple notice.
The 130 notice, that is.
Once the notice is given, if you don't answer, then the presumption directly operates against you. And 130 is maintainable.
Fact is different, my lord. There is, my lord, fact is different, my lord.
Law is not different.
Lordship for a moment, lordship not the matter can be settled, my lord. Lordship want the matter can be settled. Lordship for a moment, item paragraph 13, my lord.
Yes.
I know the accusation is 2019 through 1. So cover the relevant person, third line. I had told the sub-register I have received the consideration amount, my lord. The deed contained recital mode of payment. My elder son Gangarath was with me at that time. I read the deed and understood the same. My son had also seen it. I got the check from the accused, my lord. Regarding my lord.
That is your merit now.
My lord, he has received the amount, my lord. That is, I have also annexed the salary, my lord. Lordship can see the.
Sir, you should have replied to the statutory notice saying that.
Only because I have not given the reply of the statutory. I will not suffer, my lord. That is absolutely, there is no left debt or liability, my lord. I pray one. Can I pray one thing, my lord? Lordship, issue notice, my lord. Direct to for settlement, my lord.
Subject to the deposit of 10%.
If I lordship deposit that matter will infectious,
it will not be disbursed.
That matter will infectious, man. That after the civil suit is going on. I am absolutely not liable to pay, my lord. That he has taken the check. He has said, "Neji check on jaga dava pe." He is admitted in cross examination. Lordship can the next page, my lord. He has admitted.
Then why are you wasting time? You can argue it and you will be acquitted. Legally recoverable debt.
I am
there is no legally recoverable debt.
If deposit the refund is very difficult, my lord. Lordship knows how the matter the amount will be refunded.
Oh no, that will be adjusted. I will make it.
I am not illegal pay a single pay, my lord.
I know.
If I legal,
listen to me.
My lord.
The amount which is directed to be deposit, the civil suit is pending. Deposit, you deposit it. That will not be disbursed.
Man, the civil suit, my lord, regarding the my lord, that possession, my lord. He has, till that he has not given the possession. He has taken the check, my lord, for the other land, my lord. Since the other brothers are they are objected, my lord. Then that is the lordship. That is the record, my lord. If a lordship can see the page 16, paragraph 16, my lord. Very next page, my lord.
Are you into property business?
My lord.
Are you into property business?
That is my lord.
That's the catch.
That is the cross, my lord.
You are in property business.
My lord.
आठ पैसा नियो ताकू दियो ताठ पैसा नियो ताकू दियो आपको चेक दियो ये सब काम करते
हैं सी कहितले अन्य भाई मानक
that is the reason you have not replied to the 130
that is देन तो से that is mr my mistake, my lord. Can you play one lordship direct
mistake has to be now
lordship matter can be settled, my lord. I have taken instruction, matter can be settled. Lordship the medicine center matter can be settled. If any date your lordship fix the matter can be settled.
You bring him.
Lordship fix a date so that he will be present, my lord.
Simply issue notice.
Lordship, the further proceeding can be
no. What is the question? What is the question of further? I am not inclined to entertain this petition.
In spite of, my lord,
I am not inclined. You have to pay.
Then I lordship simply issue notice.
You have to pay. I am not inclined even to issue notice because you say that I'll.
The matter can be settled. If a lordship,
you are a property dealer.
Lordship, record my submission, the matter can be settled. I have taken instruction, the matter can be settled.
No, the land council petition submits that there is a possibility of settlement. The present case is arising out of complaint under section 138 NI Act. Therefore, I am persuaded to issue notice so as to explore the possibility of settlement. Issue notice to the opposite party. You settle it better because you are property dealer. You have taken.
ପଇସା ନେଇଛି ଆଜ୍ଞା ଅନ୍ୟ ପ୍ରପର୍ଟି ଦବା ପାଇଁ ସେ ଅନ୍ୟ ପ୍ରପର୍ଟି କେସ୍ ପାଇଲି
ପଇସା ନେଇଛନ୍ତି କାହାର ପଇସା ନେଇକି ତାକୁ ଦଉଛନ୍ତି ତା ପଇସା ନେଇକି ତାକୁ ଦଉଛନ୍ତି
ଆଜ୍ଞା ଏଇଗୁଡା ତ ହୁଏ ବିଜନେସ୍ ଇଏରେ ଆଉ
then you have to pay.
other matters also same matter then
You only can't be smart.
well
The purchaser can also be smart sometimes.
no he is not a purchaser, he is the seller proper, he is the seller.
Anyway,
the seller or the smart agent
get ready and settle it.
yes I am ready to settle man today morning I have also taken a instruction matter can be settled if let's
Second week de do. Second week.
if let's send the matter for
possible
mediation
we'll
settle
send it to
settle.
mediation and
Okay. Other matters the same matter.
at least you'll get rid of that civil suit and all.
Aye.
If you settle it.
Well
Bring it. Yes.
32 ସବୁ ସେମ୍ ଚାରଟା ଚେକ୍ ଦିଆଯାଇଥିଲା ଚାରଟା କେସ୍
31
30 31 30 29 30 31
30 to 33 ଯାଏ
32 ପର୍ଯ୍ୟନ୍ତ
39 to 32 ହଁ ସବୁ ସେମ୍ ଅର୍ଡର
Same
କରିକି why don't you all the complainants are
all
different?
କମ୍ 26 ଲକ୍ଷ 60,000
Complainants are different.
ସେମ୍ କମ୍ପ୍ଲେନେଣ୍ଟ ସେମ୍ ଚେକ୍ ଚାରଟା ଚେକ୍ ଡିଫରେଣ୍ଟ କେସ୍ ଚାରଟା ଏନସିସି କେସ୍ ଚାରଟା
Persuade him and bring him.
ନା ଟୁଡେ ମର୍ଣ୍ଣିଂ ଆଇ ହାଭ୍ talked with him he is interested to
And
settle
shall
the
I keep
matter
it in next week?
next week କରନ୍ତୁ ଅନେକ କ୍ୟାପିଟାଲ ରଖନ୍ତୁ next week I have no objection
Next week
ଏଇଟା notice ଟା ଯିବ ଆଜ୍ଞା unless he will appear my lord you can matter
that's what I'm saying. If you are in touch with him, I'm issuing notice. Take the notice, Dasti, and
then let's see one week after I will send through praise to postman
33. I am on virtual mode, Your Lordship. Your Lordship, in this matter, I have got instruction from my brother, Advocate Amlan Mohanty, that the OP number 3 is physically being present today before this honorable court, and he seeks time till 2 o'clock. My lord, after lunch, if it can be taken.
okay.
Copy, my lord, copy maybe sir.
Let us see.
Yes.
Settlement of yes.
34.
Yes.
Item 34, Your Lordship.
Yes.
Yeah. May I please, Your Lordship, that
Yes.
I am the informant, my lord. That the total witness annexed to, my lord, running page 19 to 26, 26.
This is the matter which you have been mentioning.
Yes, my lord.
Okay.
2 times. My lord, now 8 witnesses are vital witness, my lord. They did not be examined till now, my lord. Now it is posted for the judgment, my lord. We have called for the in that way. ମାନେ 8/5 କୁ ଜଜମେଣ୍ଟ ପାଇଁ ରଖି ଦେଇଛନ୍ତି ଏ 8ଟା ୱିଟନେସ୍ ନ କରିକି ଜଜମେଣ୍ଟ କୁ ରଖି ଦେଇଛନ୍ତି
ନାଇଁ you are the complainant.
I am the informant. Bas, yes, my lord.
Informant.
Informant
The prosecutor may be willing not to examine the witnesses. Those who have been maybe some
ଇଞ୍ଜୁରୀ ରିପୋର୍ଟ ମୋର ଅଛି ଇଞ୍ଜୁରୀ ରିପୋର୍ଟରେ ମୁଁ ଡକୁମେଣ୍ଟ ଗୁଡାକ ଦେଇଛି ମାନେ ଏକ୍ଜିକ୍ୟୁଟ କରିବା ପାଇଁ ସେଟା ମଧ୍ୟ କରୁନାହାନ୍ତି ମାନେ ସେଟା କୋଅପରେଟ କରୁନାହାନ୍ତି ମାନେ
କିଏ କରୁନାହାନ୍ତି? The prosecution might have taken a call out of the witnesses given in the charge sheet. They might have chosen
Yes, my lord.
few witnesses to drop.
Yes, my lord. That is
You are the complainant. Why are you worried? Prosecution might have brought on record the
my lord vital witness, your lordship, that ମାନେ
vital for you, not for the prosecution.
yes, my lord, that ସେମାନେ
You should
କହିବେ
have persuaded them.
18ଟା witness ରୁ 8 witness is not examined, my lord. Now
Yes, Mr. Rahul.
my lord, we have kindly
He is the complainant. He says that there
yes, my lord, a victim has been examined. Thereafter we have given to the some relevant documents that government is not exhibited. So we have recalled the
your prayer is for recalling the witnesses for the further examination.
no 8 witnesses are there in vital annexed. You may kindly see annexed 3 series. 18ଟା witness ଯାଇଛି 26ଟା witness ରୁ 18ଟା ଯାଇଛି
Sir,
ଆଉ
which-
8ଟା witness ଟା
you are agreed by which order?
my lord ସେ ଜଜମେଣ୍ଟ ପାଇଁ ପକେଇଛନ୍ତି my lord ମୁଁ ଦେଇଥିଲି ସେଟାକୁ without information.
ଆପଣ ଦେଖନ୍ତୁ ଆପଣ prayer ଟା.
Just see the prayer. Can 482 court allow this?
The petitioner victim informant therefore prayed this honorable court may graciously please to serenely consider the facts and circumstances of this case. The present petitioner informant victim may pass an order for an examination of 9 witnesses out of a total 26 witnesses,
my lord.
and further examination of 2 witnesses,
How can I
namely
pass the order?
Sushma
It is
Kujur and
prerogative
Sanjay
of
Kujur.
prosecution. I can't guide them. You do examine this witness, that witness.
No.
How can I do that?
No, I am not saying, my lord. Without
That is your prayer, sir.
9 witnesses are not exam, 8 witness ମାନେ ଗୋଟେ examination ହେଇଯାଇଛି ମୁଁ ପାଇଲି କିନ୍ତୁ 9 witness 8 witness
You may be correct, but can the 482 court direct the prosecution to examine this witness or that witness? That is their prerogative. If they will not examine, the accused will get benefit.
Yes, my lord.
Then what can I do? I can't guide the prosecutor. This is not a advisory jurisdiction. I'm exercising.
ମୁଁ recall କରିବା ପାଇଁ ମୁଁ application ଦେଇଥିଲି ସେଠି
What is the order?
They did not be passed, my lord, anything now.
This application is not disposed of.
Yes, my lord.
Right down. The present petition is filed by the informant.
13/3/2024
One minute, I'll try to address. Informant. Informant inter alia praying that the prosecution may be directed to examine 9 more witnesses out of 26 witnesses cited in the charge sheet. According application dated 10/4/2020. 10/4/2020. This application has not been decided by the court below, and the matter is now in concluding. Matter is now kept for final hearing. Final hearing. Next paragraph. Taking into consideration the peculiar facts of
relevant document
the related trial court. Which court is this?
And that is, my lord,
Additional discharge, district and all these applications put forth by the said application. He has also relied upon various documents. He may rely upon those documents at the time of hearing of the application.
Yes.
Go and argue with it.
Yes,
Mr. Rahul, just pass on.
Yes.
Maybe some vital witness is not examined.
Yes,
Let's check it up.
Yes.
Ordinance actual copy may be given, my lord.
Give it.
Yes.
Yes.
Obliging.
Press appeals.
Where is that?
35.
Appeal.
Press appeals. Press appeals.
Press
Appeals.
My what? Press application.
Criminal appeals.
Appeal. Press appeal. Okay. Yes. Yes. Yes, madam.
Madam, the appellant convicted on the section 13(1) CD and 13(2) of the PCR and 460, 471, 477 and
Show me the sentence.
3 years, madam.
3 years.
Yes.
Running page 46.
Okay. Appeal admitted, sentence suspended.
My name shall be indicated on behalf of Vigilance Sanjay Kumar, Standing Counsel.
Appeal admitted, sentence suspended. Yes.
LCR be called for.
LCR may be called for this routine order.
Madam, this case.
I am suspending the sentence.
Thank you.
Under 4,
Madam, bail.
389. Yes, that is 389 only I am giving. Giving the relief of 389, giving the bail. Suspending sentence means the sentence already will be suspended. You are enlarged on bail.
And also
if
fine.
it is admitted,
Fine to fine and relation of fine.
My lord, this case, my lord, to stay relation of time.
A relation of fine.
a relation of fine. What is the fine amount?
10,000.
See.
36.
The moment I say sentence is suspended, including everything.
May it please your lordship. Lordship, may I be permitted to place
Bail
on
and as well as the fine. Yes.
may it please your lordship. Lordship, may I be permitted to place on VC note? Item number 36.
Item number
36, Lordship.
Okay, 36, yes.
Lordship, the appellant in criminal appeal number 302 2024 is Indramani Dharwa, and in criminal appeal 303 is Kausalya Dharwa. The appellant has preferred this appeal against the order of conviction.
Tell me the sentence. Where is the sentence order?
Running page 81.
81.
Running page 81, 3 years, 5,000 rupees fine under section 12 PC Act.
Appeal admit and sentence suspended. Usual order. Yes.
Fine.
Yes.
And the sub-item, my lord, this appellant is in custody because of her sentence for 4 years.
Oh, bail granted. Bail granted. Bail granted. Okay. Appeal admitted, bail granted. Okay. Yes. 37.
Conviction under section 13(1)(e) read with 13(2) is sentenced for 2 years of imprisonment along with a fine of rupees 20,000.
Yes.
And in default thereof 3
Appeal admit and sentence suspended.
Gratefully.
38.
The appellant convicted on section 13(1)(c) and 13(2), read with section 468 of IPC, and he has been
What is the
sentenced
sentence?
3 years, my lord.
3 years.
3 years. Same. Appeal admitted, sentence suspended. LCR called for.
Stay relation of fine.
Mr. Das number. Name everywhere.
Stay relation of fine is there.
Yes, suspended means everything is suspended. Yes. 39.
39 appellant is convicted under section 13(2) read with section 13(1)(d) 7 of the PC Act. Internal page at 85, running page at 70.
Tell me the sentence.
Sentence is of 4 years.
4 years under section 13(2) read with 13(1)(d).
13(1)(d) and 3 years.
3 years in under section 7 PC Act.
Suspended. Have you undergone anything?
My lord, at that point of very small portions, 1 month only she was.
Suspended. See.
40. May I please,
Lord,
Lord,
see,
my lord,
please,
sentence of a year, 5 years, my lord.
5 years.
My lord.
Already undergone how much?
My lord, 1 month.
Huh?
1 month, my lord.
1 month.
My lord.
Oh. Can take to 1 month already undergone. Huh? That's suspended. Okay.
My lord, bail.
Are you in custody?
My lord, I am in custody.
Right now you are in custody.
My lord.
Bail granted. Huh?
My lord, and stay of the fine amount.
Sentence.
My lord, my humble request before your lordships, my lord, that I have wrongly mentioned as Pratap Kumar Kesari, Pratap Chandra Kesari. That
Submits that inadvertently in place of Pratap Chandra.
my lord, Kesi.
Where have you written? He has written Pratap Kumar Kesari.
My
He wants to correct the cause title. The same may be done.
My lord, you lord, my candidate to serve the copy.
My lord.
Save the copy. Yeah?
My.
Yes. Yes, next. 41.
May I please, Your Lordship? There's a conviction under section 13(2) read with
Tell me the sentence.
3 years, Your Lordship.
3 years.
3 years.
Running page 72.
71.
Yes, appeal admitted, sentence suspended. Okay. 42. Same order.
42 is the same trial, co-accused, co-appellant of 41.
Same sentence.
Same sentence. Co-appellant of 41, item 41.
Same.
And this matter may kindly be whenever listed, 42 may be listed along with 41.
41, 42 tag karo. Huh? Arising out of the same FIR. 43. Sub item ko look at the what?
Your Lordship, stay release. There is fine.
Suspended everything.
Obliged.
43. Only tell if you are in custody, then bail get.
2 years conviction on 13(2) read with 37 PC Act. My lord.
Okay. Admitted. Sentence suspended.
May I pray before your lordship granting free copy of all these orders to communicate to the Trial Court? All these free copies may be granted.
To Mr. Das, huh?
Obliged, my lord.
Yes. 44. Yes. 44. What is it? Revision of. Where is it? Why it is separately listed? Press meter. Press revision.
44, Mr. Sangram Das is in charge of this file, maybe passed over or taken up after lunch.
45.
Belgium. 45.
45.
Mr. Maharaj, just see.
Yes, sir.
These are bail jump matters unnecessary.
Bail jumping.
Can't pass over like this.
4/1/2023 NBW.
NBW 4/1.
2023.
Bail.
Yes.
Bail is
At the
14.
stage of the accused statement was absent and NBW issued.
ठीक है 14/10/2012.
Yes.
Bail. And NBW is on
4/1/2023.
4/1/23. ठीक है 30th में कर दियो 500.
46.
My lord, this Belgium matter,
Hmm.
order dated 30th November 23.
Bail.
This stage of trial, stage of framing of charge, my lord.
26/11/21. 26/11/21 bail. And NBW on 30th November 2020.
My lord, 23,
23.
annexure 1.
How many of you are on?
Miller?
500, huh?
Yes.
Obliged.
Yes.
47.
Absconder NBW.
For 47, I may permitted, my lords. Prior to
Yes.
submission of final form, my lords, NBW was issued on the prayer of the IO.
Petitioner was charge sheet was when charge sheet was filed. Petitioner is an accused in FIR number so and so. The charge sheet was filed showing the petitioner is an absconder. Therefore, on the request of the police, NBW was issued. NBW was issued against the petitioner on 10/9/2019
5/8/2019.
by the SDJM Bhadrak in GR case number 425 of 2019. Same order.
My lords.
Then you have to pay 1,000.
My lords, NBW was issued on 5/8/2019, my lords. 5/8.
5/8/2019.
My lords.
No, 1 minute.
47.
47,
my lords.
1 minute. You are writing something in the prayer. What have you written?
And 10/9/2019, cognizance was taken, my lords.
Cognizance was taken. NBW issued on?
Issued on 5/8/2019, page 10.
1,000.
My lords.
Yes.
48.
48, your lordship may kindly see page 17. So something is there. Page 17.
17.
Belgium case, lordship. Let's say what page 17, lordship, got it? Order dated 24/2/2020.
24/2.
Yes.
Yes.
Accused person except Sarat are independent under 317 CRPC for today only. Advocate for the accused Sarat placed for time for appearance on the grounds to therein. Hard. In view of the order past dated ethically, the time petition stand rejected being developed. What that order? I don't know. That 22/1/2020. That order found in the
Anyway, you were seeking adjournment. It was he will appear. Whatever.
That's it.
That's true,
Right,
Lord.
lordship, that.
You are on bail when?
Yes, well, I'm in bail since 20. Just your lordship, a glance. That is page.
Tell me the date.
That is lordship 10/3/2009.
10/3/2009. NBW.
NBW lordship 24/2/2020.
Give 10,000. Sorry, 1,000. Because you are appearing. You should not have come. And you appear, therefore he kept on searching something to oppose you. He thought that there must be something because a senior counsel is coming. Sometimes it is counterproductive.
Both of them belongs to one chamber, man.
That is the reason he was searching. He comes means there must be something serious. Yes.
49.
May I please, Mala, this is a Belgium matter. NBW issued on 13/10/2011, Mala. He was released on bail on 15/1/2005, Mala.
5, huh?
Mala. I have annexed the order, Mala.
And NBW is 13/10/2011.
Mala.
1,000.
Obliged.
Yes. 50. Yes.
My lord, the bail was granted by this honorable court, subject to the conditions that at the first instance to pay the demand draft 10 lakhs to the informant. And the rest 10 lakhs, the first installment after 3 months, thereafter the subsequent 4 installment to be fixed by the learned court below. And in the meanwhile, if your lordship kindly find page
Now NBW has been issued because of non-compliance.
because of non-compliance means already 15 lakhs has been paid because subsequent 10 lakhs has to be paid in 4 installment.
You defaulted in making payment.
We defaulted in making payment of already out of 4, 2 already paid.
How much time will you take to pay? You just
My lord, already demand draft is there of 250,000, 2,50,000. I have given the copy thereof, your lordship direct that that can be submitted before the Lord and lower court, and that will be handed over to the informant. And for the rest, your lordship kindly grant 3 months time because 3 months time.
See, I can't change the condition of the bail because that is the prerogative of that court.
No, not like that. This honorable court already left to the liberty of the Lord and lower
Where
court.
is that? Where is that? Sure.
That order.
Page 20.
नहीं সেটা এই কোর্ট না honorable court ର हाँ এটা page 18 রে
18 रे
ଆଜ୍ଞା Admittedly, it is directed that in terms of para 2 of the affidavit sworn to before releasing the petitioner on bail, the Lord and court in season shall ensure that demand draft to the tune of 10 lakhs in favor of the informant without prejudice to the right of the petitioner and co-accused is handed over.
Which you have paid.
We have paid the 10 lakh already paid.
The petitioner shall pay
Yes.
a sum of rupees 10 lakhs by way of a demand draft to the informant.
Yes.
The
That has been
first
paid.
installment thereof
Yes.
would become due after 3 months
After 3 months.
of his release.
Okay.
And the said amount shall be paid in 4 equal installments.
Yes.
Date of which shall be fixed by the land court.
Yes, yes.
Date will be fixed by the land.
Yes.
fix kale date fix kale
Court fix is page 22 रे page 22 रे
22 रे ना
आज्ञा page 22 रे
ସେଟାକୁ ଦେଇ ପାରିଲେନି ତେଣୁ ୱାରେଣ୍ଟ
Right.
କହି ଦଉଛି
By order dated, right. By order dated 13/4/2023, the coordinated bench of this court, while disposing of BLAPL number 22 of 23, enlarged the petitioner on bail with a condition that he shall deposit 10 lakh rupees upfront, and thereafter further 10 lakhs shall be paid by him on equal installment, and the date of the payment of such installment shall be fixed by the court below. Learned court below fix the dates for paying the installment. However, the petitioner
already paid 2 installment.
Petitioner paid 2 installment, and the subsequent installment could not be paid by the petitioner, and due to said default, the NBW has been issued
Yes.
by the court below on
That is on
19/1/2020.
At present demand draft is copy I have given.
How many
That is
demand
right. 2,50,000.
50,000 yes
Mr. Mohanty, learned senior counsel appearing for the petitioner submits that meanwhile 2,50,000 the demand draft of 2,50,000 rupees has already been tendered.
No, already ready. That could
Is ready.
Yes. That
Ready,
copy I have given.
and he is willing to submit it to before the trial court.
Yes.
And further installments he shall be he shall make good the payment towards the further installment within 3 months.
Ma'am.
3 months. Taking into consideration the statement made by Mr. Mohanty at the bar, and subject to depositing 2.5 lakhs draft,
Yes.
2.5 lakh draft before the trial court, the NBW issued on 19/1/2024 by JMFC Roman 4 Bhubaneswar in CT case number 6296 of 2022 is set aside. It is set aside.
Yes.
The petitioner is also liable to pay. How much you will pay to the bar? 1,000.
1,000.
Sir is appearing, then it should be 10,000.
But client has to pay.
Anyway.
My lord, your lordship, direct on depositing that 2,50,000, that will be handed over to the
And
informer.
the draft of 2,50,000 rupees, which would be deposited by the petitioner, shall be disbursed to the.
At present.
Huh?
That is to be handed over to the informant.
Disbursed to the informant.
Yes.
As per the direction of this court, dated. Direction of this court dated. As per the direction of this court, while granting bail to the petitioner.
Madam. Will your lordship fix any time to appear?
Set aside 3 months I have given you.
May I please, your lordship? So, based on matter, my lord, NBW.
See, the problem is, the Supreme Court says that no onerous condition of depositing, but you have made the statement before trial court while getting bail.
Yes, sir. Yes.
That I am ready to deposit.
Yes, sir.
So you have to deposit. Anyway.
May I please, your lordship? It's the Belgium matter, my lord.
Yes.
NBW was issued on 17th July.
Yes.
2010, my lord. At page 7 annex of 1, my lord.
2010.
My lord.
You were on bail?
My lord.
Did give the date?
That particular date is not here with
He
me.
was on bail. He was on bail, but default 17/7/2010. 1,000. NBW.
My lord, 500. Poor.
2000 17/7/2010 2010 ना?
Hi, my lord.
1,000. चलो 500.
52. Passover matter. Item 45, my lord. My lord, item 45.
45 sorry है कि अपन dispose of है allow है.
Allow है. Yes. Next.
410/23, my lord.
Huh?
410/23, my lord.
Individual 410/23.
My lord.
And bail?
26/23.
Okay, sir. 500. Yes.
53.
53 not pressed.
Not pressed.
Arrest.
53 not pressed.
54.
54 Belgium matter, my lord.
Hmm.
Bail was granted on 2011-2019 and NBW issued on 3/8/2023.
500.
Oblige.
55.
My lord, NBW was issued on 24/6/29. 24/6/19, my lord.
NBW 24/6/2019 and bail
13/10/13.
13/10/13. Okay, 500.
56.
Madam, Belgium matter, NBW 25/2019, my lord. We released on bail on 14/12/2005, my lord.
Okay, 500.
57.
Belgium matter, my lord.
Yes.
NBW 15/11/2023.
Yeah.
Bail date अपन.
Build it 10/12/2018.
10/12/2018 और 15/11/2023. ठीक है. 500.
58.
May I please, your lordship?
You will see the files very carefully. Every time the applications are coming, somewhere the number is different, somewhere the dates are different. Check it up carefully. Check it up. Yes.
58, my lord, 138 of NI Act, 205 petition was moved, that was rejected, and NBW has been issued.
Yeah, I would
This is not a, this is not a 138, it's a 420 and other offenses.
Anyway,
it take a problem.
57, 85.
Page 14 also.
14/14.
Yes.
Yes.
I'm just starting reading from the back side. Here is the case record is saying that cognizance of offense 138 enact is taken by the order dated 4/5/2022 by this court, and accordingly someone was issued to the accused person for his appearance, but the accused person did not appear earlier. This court has rejected the petition under section 205 of CRPC. On 21/6/2022, page 14, bailable warrant was issued against the accused person, which was executed by the concerned IAC, and the accused person was released on bail from the court of the executive magistrate of Patangi by the miscase number so and so, who directed the accused person to appear before this court on 12/12/2022, but the accused person did not appear before this court on the date fixed. On 18/1/2023, NBW was issued against the accused person and the record is lingering from production of the accused person. So this is the crux of the case.
Accused petition filed another application. under
Yes, yes.
205.
Usually, my lord, in 138 case, 205
Actually,
usually
sir,
are
apply করে রাখা থাকে।
It's not, he says that it's not only 138, it is
no only
other
130.
offenses also. A lot of-
130.
ସେ part ବି ଛାଡ଼ିଦେଲେ ଯଦି ଗୋଟେ କୋର୍ଟ ପ୍ରୋଟେକ୍ସନ ଦେଇଛନ୍ତି ଡାଇରେକ୍ସନ ଦେଇଛନ୍ତି ଏଇ ଡେଟ୍ ରେ appear କରିବ ଅଲଗା କୋର୍ଟରେ ଯାଇକି
Oh,
ସେ
no.
appear କରିନାହାନ୍ତି।
Intentionally
That-
avoided
that is violated.
As your lordship said that.
No, no, you see, if you are not cancel the bail NBW, this matter will not move. So better I'll cancel it,
Yeah.
but you have pay. What he says that pay little more cost. That is what he says. Nothing else. By rejecting this pay will lead you nowhere.
Yes, exactly.
So better you appear and pay little more cost. 1,000 for the case.
Aye.
Okay.
Subject to payment of 50% of the amount related because it's a 2021 matter.
See,
and
there is one,
civil suffering.
see 143 is there, you move application. 143 application. Immediately move the application.
Aye.
Before he reaches, you move the application. The moment he goes, what will say deposit 20%.
Yeah.
61 also same.
61.
1 minute. Write down. The case is arising out of 1CC case. The petitioner was in pursuance to the bailable warrant issued against the petitioner. He appeared before the police on 21/6/2022 and undertaking to be present in the court. However, when the matter was taken up by the court below, he was absent. Therefore, on 18/1/2023, NBW was issued against him.
Yes.
Instead of appearing on the date fix, he moved an application under section 205 CRPC.
Yes.
Therefore, by order dated impugn order dated 4/1/2024, the said application under section 205 CRPC was rejected and NBW is issued.
Aye.
Petitioner is agreed by the said order. And he undertakes to appear before 30th May. So, ठीक है? 1,000 को, ठीक है?
1,000 to complain and yourself bar before bar.
Bar welfare.
You wasted lot of time of the court.
I-
133.
Item 61 also same.
No, you say item 16 is different because it's a different.
Come read.
Yes, yes.
Wait.
59.
Item 59 also the Belgium metallurgy.
Yes.
NBW has been issued on 3/11/2023 and the petition was on bail on 24/12/2014.
500.
24/12/2014.
14.
14.
ठीक है.
60.
This is a Belgium matter, my lord.
Yes.
The petition was bailed out on 10/12/2019 and NBW was issued on 22/10/2021. At page
2021.
21.
21.
22/10/2021.
500. ठीक है.
61.
61 also same, my lord. But he has a IPC offense are there, arising out of complaint case.
The present case is no, same 205 is rejected.
Rejected and
The
that
petitioner the present case is arising out of ICC case number 106 of 2021. Summons were issued to the petitioner. Instead of appearing before the court, he moved an application under section 205 CRPC, which was rejected and NBW was issued by the impugn order dated 4/1/2024. ठीक है? तापर बाकी सब कर दो 500.
It is same
Same,
order.
but not 138
Same
or
order.
130.
NBW was executed by another court and he was directed to appear before this court.
same
Now he will appear-
same order, my lord.
Same order ଟା ହେବ ଖାଲି ଡେଟ୍ ଗୁଡାକ same order ହେଲା ସେ ଯୋଉ order ଟା
ସେଇ ଅର୍ଡର ପ୍ରଥମେ ଯୋଉ କରିଥିଲି ସେଇ ଅର୍ଡର ସେମ୍ ପ୍ୟାଟର୍ନ ଲେଖିଦବ ଡେଟ୍ ଗୁଡାକ ଚେକ୍ କରି ଚେଞ୍ଜ
ଡେଟ୍ ଗୁଡା ଖାଲି ଚେକ୍ କର
62.
62, 63, 64. One petitioner, but GRK is different. Previous warrant ହେଉଛି 20/5/23, previous bail ଥିଲା 18/10/22.
18/10/22
Bail was
bail
bail.
and 20/5/23
23
NBW
NBW.
500. Yes.
Bail
Cancel.
ତିନିଟା ସମାନ.
All the three matters.
Field, ହଁ.
କୋଉଟା କୋଉଟା 62, 63, 64.
62, 63, 64.
But dates are different.
ନାଇଁ ସବୁ ଡେଟ୍ ସମାନ. 20/5/23, 20/5/23.
same
Bail ଗୁଡାକ
ବେଲ୍ ଗୁଡାକ ସବୁ ଗୋଟେ ଡେଟ୍ ହେଇଥିଲା 18/10/22 ରେ.
NBW same.
Court also same.
Accused same.
Accused same.
Three cases, sir.
ठीक है
Yes, sir.
बासठ तिरसठ चौसठ ठीक है सेम ऑर्डर ठीक
65.
May I please, Your Lordship? The NBW issued on 11th, 2022, and the petition and the accused religion bail on 24/10/2011.
11
Yes.
500
Okay.
yes
66.
Please, Your Lordship.
yes
Your Lordship, herein we have prayed for cancellation of the bail of the opposite party number 2, Your Lordship.
bail
Yes, Your Lordship. The bail application was earlier dealt with a coordinate bench of this Hon'Ble Court, Your Lordship. So there the bail was not granted to the present petitioner, Your Lordship, present opposite party number 2, Your Lordship. However, subsequently, on the very same day, suppressing the filing of earlier bail applications, he has been able to obtain a bail from the Court of Learned Magistrate, Your Lordship.
it was rejected by the
Yes, Your Lordship. It was disposed of as withdrawn by a coordinate bench of this Honorable High Court, Your Lordship.
withdrawn is something different
Your Lordship, but there was a specific direction on the same day without disclosing that there's a pending bail application before this Honorable Court.
no, when the trial court granted bail that time the
Yes,
petition
on
was
the very
pending.
same day. On the very
and
same
thereafter
day.
he got the bail and
Yes, Your Lordship. Yes, Your Lordship.
yes
Also, Your Lordship.
I'm on behalf of Mr. Ponda, Your Lordship. He's on accommodation, maybe adjunct.
This is tactfully you are handling tactfully you are handling because cancellation of bail if time passes then you will see that now he is in the liberty why should we interfere the court will not interfere that is the idea but what to do is an accommodation
Your Lordship, last
but
time.
recently I tell you recently the same thing happened Supreme Court has
Yes, Your Lordship. That's what
passed serious orders
Yes, Your Lordship. Also,
how can if the case is pending before High Court you don't disclose get the bail and thereafter you come and withdraw it
on the very same day, Your Lordship.
on the same day this is very serious matter on merit you may be entitled for bail that is a different story but the propriety demands that you should have informed to the court I'll keep it short date next week
Your Lordship.
next week right on behalf of Mr. Devasis Ponda appearing for opposite party number 2 adjournment is sought which is opposed by letter counsel to petitioner in the interest of justice adjournment.
Any date next week, Your
Next
Lordship.
week.
Much obliged, Your Lordship.
67.
Please, Your Lordship. Next is a cancellation of bail, which was granted in favor of the OP number 2 to 7. And the learned magistrate, JMFC Kujang, has allowed the bail and they are violating the conditions of the bail. What has happened? The petitioners,
Who has given the bail?
the learned magistrate, JMFC
The
Kujang.
violation means you go there only. Ask for cancellation.
Lordship also filed here also
if
the application.
bail conditions are violated.
Yes.
The
We had
court which has granted bail, you go there and ask, these are the conditions you impose and these people are violating.
Yes, they are also, we have filed, they have, they are also, we have filed. But only reminder is there where you are indulging the such activities of they have stated. Let's see, which is Paradip International Cargo Terminal Private Limited. It is a multi-purpose clean cargo terminal.
See the gravity of
Let's see, they are indulged in time and again strike and they are disrupting our.
Thereafter, after this FIR, when
Yes.
they got their enlarged on bail, how many cases are registered against them?
Thereafter, 2 to 3 times they are issuing notice for strike. This is that was that was the condition. Your Lordship may see the condition was that while they are going on bail, they shall not commit similar type of offense in future while on bail. And the IOs,
Can a criminal court while granting bail pass an injunction? If they do it, they'll face the consequence.
Yes.
Separate case. And they are indulging on strike doesn't mean that their right is taken away. They have a right to go on strike. That's
Lordship, what has happened? The conciliation proceeding is going on before the Labour Commissioner. They are violating it.
You are for management.
Yes, this,
Not
we
stay.
are the management.
Simply withdraw, that's better.
Let's see
Considered petition seeks to withdraw this petition to reserving his right to file for cancellation of bail granted to the opposite parties if cause of action still survives.
68.
May I please, madam? The cancellation bail, my lord, the anticipatory bail granted by the second additional session judge, my lord, that is page 40, the order considering the what happened that the opposite party too filed 3 consecutive anticipatory bail application before this honorable court. When this honorable court directed for surrender, he has not surrendered. And thereafter, last order passed 2020 by this honorable court, but he has not honored to this order. Thereafter, she filed anticipatory bail on 7 to 2024 after 4 years. Again, filed before the session court, and session court allowed 438 petition without ignoring the order of this honorable court. Your lordship kindly see the annexure 2, the order of this honorable court.
I see. However, it is observed that in the event the petitioner surrenders before the court in session of the case and moved in their bail application, the same shall be considered on its own merit, disposed of early in accordance with the law without being influenced by this order. This is the order.
This is the first order.
In 2017, this order was passed.
Yes.
Thereafter, what had happened?
Thereafter, 19 also she has filed another. This order, there is a computer downloaded copy, and
another application.
I withdraw.
Thereafter,
And another application.
Third.
2020. That is also by my lord Justice Didas also.
Thereafter, what happened?
Thereafter, 2024 filed a anticipatory 438 petition before sessions court, and sessions court ignoring this without only she has disclosed only one petition has been filed, but government there is no government counsel for that. Now can you see the petition page with the that is page 34, my lord. My petition. That that the petitioner accused more, that is para 10, my, that the petitioner accused more further submit before this honorable court. She filed a bail number 1973/2020 before the Honorable High Court of Orissa Kotak, and also filed money suit of 20 lakhs. Due to COVID-19 pandemic, the matter has been disposed of due to state of Orissa did not appear in this case.
No, in these two orders, you are right. You have given.
Yes.
Where are the cost items? Whether
My lord, that is downloaded from the website, my lord. Cost item.
But whether it is filed by Anita Swahi or someone else, co-accused.
And dear lordship may call for the record.
No, I can't call. You have to tell. Then rightly she has disclosed.
Then I will.
You tell me whether these two. See, your case is in 2007. She
my lord,
came. 1 minute. In 2017, she came before the court. She filed the petition for anticipatory bail. The first accused is Uday Kumar Sahu and second is this Anita Swahi. And the court said that you surrender and move the application, the same shall be considered on its merit. Despite this fact, concealing this fact, he has filed the anticipatory bail.
Yes.
But that's not correct because in the petition, he has written about this petition.
Yes.
It is not concealment. Insofar as these two orders are concerned, I need to know whether this is filed by the same accused or someone else.
He is admitting in his petition before the page 34. The lordship kindly see page 34 of my brief.
Yes.
He has admitted in para 10, ABL bill 1973 of 2020, filed by the petitioner before this honorable court.
1973. This
Yes.
one.
Yes. And that is withdrawal 19 that has been withdrawn. He has not mentioned any earlier bail application, only mentioned 1973, 2020. And suppressing the all of fact, and also filed a criminal miscase, which also.
But this order says, however, observe that in the event of the petition surrender before the court in session and move their release on bail, the same shall be considered. The only thing is instead of surrendering, he moved an application.
Move an application.
What do you say? We'll simply issue notice. Simply issue notice. Simply. Yes.
69. Please, relaxation of bail condition. The petitioner is a lady. She was not named in the affair, but in the charge sheet she has been named. The other three accused person were the official. My lord.
Which condition?
Sorry?
Which condition you want?
Condition, my lord, your lordship may see page 86.
86.
86.
Yes.
The condition, she has to appear, clause number 1, she shall appear in the court on all dates to be fixed. Whereas the other three accused person, subject to 317. The other official,
Appear.
Subject to 317. Your lordship may see what are the other bail conditions. Other accused. Page 93, my lord. Page 93. At the top, he shall appear in person on each date of trial subject to the provision of section 317. Then the other accused also, page 103. There also.
Who is he? This is all accused persons.
103 clause 2, my lord.
How many accused persons? What are the offences?
Offensive Prevention Corruption Act, irregularity in the tender process.
Who are you?
I'm for the petitioner here.
No. What are you doing?
I was that time I was doing business. I supplied the materials.
Who is the main accused?
Main accused is the executive engineer, the chief engineer, and the drawing disbursing authority.
You call vigilance lawyer. 2 o'clock I'll take.
After recess.
I'll alter it. Only subject. You can't take away the right of 370. He is right. And all the other accused persons are given the same thing. He is a lady. Unnecessary.
And I am staying in Bhubaneswar. I have to go up to Pavani Patna.
370. We'll add 370. With that condition, we'll add 370.
Yes.
Same condition we will impose.
Only
call him at 2 o'clock.
Yes, ma'am.
Call him.
Oblige.
Call him. Mr. Marana or someone. Marana, Mr. Marana.
To provision of 317.
See, that will change, yeah?
My lord.
1 minute, sir. There is a mentioning.
I was mentioning today morning, unfortunately,
Yes.
there was a disconnection.
There was some problem there, that your side or this side?
I don't know, my lords. Some problem somewhere.
Maybe your internet was weak.
Maybe. My lords, here, my lords, junior engineer, my lords, his promotion is being held up because of a case, my lords, where there was a promise to marry. So they have instituted a rape case against him. My lords, that your lordship is aware, Supreme Court has already quashed. Any day subject to your lordships, my lords.
You asking for quashing or?
Quashing.
Quashing of that 376?
Yes, my lords.
The other offences will?
Other offences may remain. Your lordships, any day your lordship, subject to your lordships.
Take the memo and just see what.
Any day,
You
subject to your lordship.
Okay. Thank you. Yes, sir. You are agreed by the annexure 4, no?
Yes, my lord.
Annexure 4. Right. By the order dated, no, annexure 4. No.
And annexure 3, my lord, at page 82.
Yes, 3, na? 3, yeah? 82.
82, relevant portion 86, 85, 86.
82. No, you are granted bail by which order?
Granted bail.
Page 86, your lordship can listen.
86 is the condition.
My lord.
86 the impugned order, madam.
Huh.
Granted bail
She
by
shall,
page 80.
first condition, she shall appear in court on all dates to be fixed. Your lordship may
Very.
modify subject to provision of.
Why the order dated 23/11/2023, the special judge vigilance Bhavani Patna enlarged the present petitioner on bail with various conditions, including the condition and elevated Kumar Dikro, she shall appear in the court on all dates to be fixed. The next one, the petitioner is agreed by the aforementioned condition. Therefore, he has filed the present petition for variation of the said condition under section 439(2) of CRPC. Heard Mr. So-and-so and so-and-so for parties, taking into consideration the submission made at the bar, the condition is altered. And what is the other conditions?
Other conditions
I have not agreed, madam.
but she shall
appear
in person
on each date of hearing before the trial, subject to the provisions of section 317
of the
CRPC up to CRPC. ठीक?
Much
Obliged, madam.
Item 12.
12, yes. Yes, sir.
I pray for classing of the proceeding. Also kindly come to that Annex 1. Here, alleged offences are 341, 323, 506, 307, 490,
Yes.
34 of the DPA.
Who are you?
Well,
You are the
so
in-law.
for petitioner 1 is the husband, 2 and 3 are in-laws below. And also see at page 10, on 9/5/2023 at about 3 p.m., the written report of complaint Manasi Jangada, so and so, at present, but appear to the matter.
Come to the charge sheet.
Yes, you'll also see that I'm coming. Page 25, my lord. May I place it, my lord?
Yes.
Yes. During course of investigation, visited the spot, examined the complainant as well as witnesses, and record the statement under section 161 CRPC. Send the victim, Manish Jangada, so and so for medical examination. I have obtained injury report from the respect of Jangada Dr. S.K. Raut, MOCSA Kantanjir, Balangir, which is no recent injury marks over her body. I have seized the Xerox copy. Thereafter, lordship, come to the next page. I have verified the CA. Lordship, got it, my lord. I verified the CA of the accused person Sachin Jangada and so, but found nothing adverse against him. During course of investigation, it is ascertained that the complainant Manish Jangada has not taken any dowry articles during her marriage. Hence, dowry articles could not be seized. They'll also see the married sister-in-law and paternal uncle, they were not charge sheeted. Then you'll also see that statement of the victim, my lord, as page 33, informant. My place, my lord. मेरा नाम मानसी जंगड़ा पिता अनिल कुमार है। आज 9/5/2023 आपके पास बयान देती हूं कि मेरा बलांगीर उड़ीसा में रहने वाला सचिन जंगड़ा वो हिंदी रिवाज से शादी हुआ था। मेरा पति सचिन जंगड़ा शादी से पहले मुझे एक मोबाइल फोन दिया था और मेरा बलांगीर कंटावंज में बहुत बड़ा मकान है। मतलब he was given wrong impression that the petitioner is having belongs to a well-to-do family. Under that impression, she got married, and subsequently within 3 months of marriage.
You should notice
As you also.
He has not made the informal as a party, my lord.
You should have made the party.
I am permitted.
If there is chance
Yes.
of compromise.
And oral fair,
This is basically matrimonial.
Yes, you also see page 37. So far the injury report is concerned, no recent injury marks found over her body. In fact,
That's it.
no specific overtact, nothing. Within 3 months of marriage, she left the matrimonial house, residing in her parents' house, and reason based on to her, she has lost this affair.
Issue notice to the permission to implead the informant victim as a party respondent. Party respondent, he may do so during the course of the day. Counter handlers also. Issue notice to opposite party number 2. Written within 2 weeks. in the internagnum, the petitioner is granted liberty to move appropriate application.
No, no, we are on bail, my lord. We are on police bail, all on police bail. I pay, you also still appearance of the, there will be stay of further proceedings of that.
That's what I'm saying.
Yes, yes,
an
yes,
application.
yes, yes.
Appropriate application before the trial court, seeking adjournment, owing to the fact that the petition matter is subject before this court.
Obligation. I'll got it completed or I have to file separately?
Right,
Yes,
right now.
yes, yes.
I have issue notice. Yes. 25.
May I please, my lord, 25 amount received. For the petitioner.
Yes.
Lord, here an application filed under section 133 of CRPC by the private opposite party has been entertained and order has been passed which is under challenge. That impugn order is at page 46. It's a 46 of your lordship's brief.
Okay. Yes.
The lordship may kindly see the case record is put up today as per the date. The learned advocate on behalf of the petitioner OPs are present. It reveals from the letter dated so and so of Tahsildar Khurda that so and so or son of Sahu and have unauthorized encroach on government land pertaining to so and so. The learned advocate on behalf of the petitioner argued that due to the aforesaid unauthorized encroachment, the petitioner are facing lot of problem during the time of the land. It's an inter se private dispute between the petitioner and the opposite party number 6 and 7, and 133 has been invoked, my lord. Neither the conditional order has been passed, nor evidence has been laid, nor the report of the Tahsildar has been done. 138 has not been followed, and the unauthorized construction removal order has been passed. From 133 to 138, nothing has been followed. And in fact, the Tahsildar's report was not supplied to me to file rebuttal.
Yes, yes, Mr.
My lord. My lord, I have to take the instruction.
Then I'm issuing notice.
Hello.
Simply let us see.
Yes,
there can't be any stay because there is a kind of injunction order. For
no, that is not is hereby directed to vacate my place, my lord. That is the order against me, the petitioner.
But what is the life of this order?
My lord, that was passed in 20th February. So they are now threatening to vacate me, ma'am.
No. I think this kind of order has a life.
No, my lord. So far as 133, unlike 144, this has to be implemented by the Tahsildar with the enforcement team. So every day they are saying that you vacate, otherwise we will put the bulldozer. That is how the petition was filed.
Okay. Issue notice to opposite party number 2. In the meantime, no course of action pursuant to the order dated 12/12/2023.
The 20th to 2024. 20th February 2020.
20th February 2020.
Obliged.
Till then, no course of action pursuant to the order dated 20th February.
Obliged. Deeply obliged.
33.
Please, Your Lordship.
Yes.
Lordship, this is the FIR against unknown persons. The father of the OP number 3 has lodged a missing report before the Commando PS, stating that his daughter is missing from the hostel.
What are you seeking?
I am seeking questioning of the process.
You have not filed anything. FIR is just lodged.
Yes, Your Lordship. And 2 persons, the petitioners have been arrested.
Now they are under custody, my lord.
They are in the custody.
Your Lordships, I am appearing for the OP number 3.
How can I quash the FIR at this stage? Investigation is still going on.
My lord,
you are arrested.
My lord, the OP number 3, who is the daughter, which is alleged that she is missing. The FIR is only a missing report. In the FIR, there is no mention of any name.
Statement of a victim has not yet been recorded. The statement of a victim.
164 statement of the mother of the victim has been recorded by the police. The victim.
Why you were arrested then?
The police knows that.
You have got to pay, have you applied for bail?
Yes, sir.
Rejected.
No. It is posted to tomorrow. The opposite number, party number 3 is present, who is the daughter of the opposite party number 2. She has not been kidnapped by these petitioners. She has gotten married only after she turned 18. She has gotten married on the 10th of April 2024.
With whom?
With the son of the petitioner number 1.
Rupesh Ranjan.
Yes, his son.
Son is not an accused.
No. He is staying in that village. He has not been arrested.
What do you say?
Your Lordships, I'm appearing for the OP number 3 and she files an affidavit today that she has gone on her own volition. She had left the hostel.
No. Well, there is nothing. The girl is above 18 years.
My lord.
He says that I have never been kidnapped.
Yes, my lord.
And FIR is lodged by the father of the girl. And on that basis, you have arrested these people.
My lord, after 363, it is turned to my lord 366, 346, 141, 120B, my lord.
Those persons before your lordship have filed this application. They are
father of the boy.
Father and uncle of the
boy.
Now they have been arrested for under section 363, 366, and
120B.
120B.
That's right. But the girl says that I have not.
But till today, the girl has not been rescued.
Rescued.
Unless
married to the boy.
Maybe, but she has not been rescued. Her statement has not been recorded. Then supposing, my lords, for an example, the girl died. Who will be responsible?
All these things are.
Now the police is responsible because it is under investigation.
See, one more problem is the mother of the girl has deposed under 164. So that may be the reason why they are.
My lord, I have
one suggestion, my lord.
File a quashing.
Produce the girl before
Produce the
investigating
girl.
officer. Let her.
She's already here.
Recorded.
She's already there. The girl is there.
Yes,
So let her to produce the. You also may fix up a date. Let the petitioner to produce the girl before the investigating officer. Her statement.
Where is the husband? Her husband.
Her husband is no. He is outside. He is in the village. She has come with the brother of.
He has to also come.
Yes.
Direction
In any case, tomorrow you have the bail application.
Yes, sir.
You come out first.
Yes.
Or then next week. First you come out.
Okay.
Then you see. Come out, then we'll quash it if we come out. It appears that the parents are not willing for this alliance.
She went out of her hostel because immediately after 3 to 4 days, she was about, not in 1 month time, she was about to become 18 years old, and they were already fixed up a marriage with some other person. She didn't want to get married. That is the reason why.
The problem is father-in-law and uncle, both of them had gone to jail, and they'll come and they are supporting the husband of this girl. And once they went to the jail, they'll come and say that at your instance we have gone to jail. We will not support. That will be another issue.
No, your lordship. No, that will not be the issue. As well.
Let them come out.
And the 164 statement of the mother, coincidentally, I have read it when it was done in the court. I have read it, and in that there is a specific allegation that emane bhola pautile se taku mobile deithila se tari sange jaithai pare. Not even that.
Anyway, let's see. This is very. I am keeping it next week sometime. And first you get the bail and come out, then we'll see.
So the affidavit be taken on record so that I can.
Appearance and the so enter appearance on behalf of opposite party number 3. Opposite party number 3 and filed an affidavit will be taken on record. What about opposite party number 2?
That notice needs to be taken because
notice to opposite party number 2.
The shortest date may be fixed.
Rahul notice for opposite party number 1. Okay.
Yes.
Obliged lordships.
44. Item 44 on behalf of Mr. Dayanda Mahapatra may be taken up next week.
Press matter.
Just to 11.
Item 88 mentioned.
Yes,
44, 11.
Yes.
My lords, these two criminal miscases are squarely covered
by your lordship's judgment delivered on 8th of April, sorry, 15th of April 2024, that relate to the late deposit of the tax TDS within the stipulated period.
How much?
It is from 3 months to 12 months, and the amount is, my lords, only.
And you are covered by that
yes,
notification.
by that circular. Exactly, I am giving that circular. That is
In that case, I remember.
Yes.
That was 394 days or something.
Yes.
Year less than
12 months. Yes. And I am giving that circular again.
Have you challenged that order somewhere?
My lord, actually, I have some submission. Actually, the concerned petitioner here, my lord, he has deliberately defaulted in depositing a TDS amount. Mr. Jaswant Singh, who was the director of the company and solely responsible, he was, not depositing that TDS deliberately. Yes.
Deliberately.
And the prosecution has been launched, and the provision 278B of Income Tax Act. Well, hello, what exactly the people who are responsible for deducting the TDS and not depositing, they're taking the advantage.
He has now deposited
with interest, my lords, prior to
the
launch
law
of the
laid down is
prosecution.
once you accept the
Amount.
with
Yes,
interest.
with interest.
Thereafter, you can't lodge.
Yes, that is the
You
circular.
should initiate before depositing. Thereafter, I
And
can
you have
understand.
to, my lords, you have to
That's the law.
say that assess is in default.
Have you given that judgment to?
My lords,
Give that.
he also was appearing, my lords.
It says
That circular, I am giving a
Very-
lots
very-
of judgment.
very-
Yes,
very-
judgment I am giving. I am so sorry, my lords. The judgment, my.
These are the circular you are covered by that.
Yes, yes. Squarely covered, my lords.
See, the judgment of the court.
My lords have relied on the judgment of the Jharkhand High Court and
Jharkhand High Court
also
says
our
once you-
own High Court, which has been confirmed by the Supreme Court, that Jharkhand judgment matter. That is, they.
The page 5, if you see.
Yes.
It was covering the COVID period, minus the delay period. It was.
No, it
within-
says.
You are unaware of the provision under section
No, no.
278AA.
No,
Reasonable cost.
No, it says the amount has already been deposited with interest.
Yes.
There is no reason why the criminal proceeding shall proceed. And the criminal proceeding was launched after receiving the said amount.
Yes.
Once you receive this amount, you can't do it. That is what
Yes.
I have said.
Yes.
Unless this judgment is upset, he is covered. If you have challenged it, that's a different story. You are entitled to do that.
They cannot also challenge, my lords.
I'm issuing notice and keeping it next week.
My lords, notice was issued, my lords.
No, he is not appears to be not ready.
My lords, notice was issued earlier.
In both the cases,
other, yes.
both the
Notice
cases, you
was
file your
issued.
response. If you have anything contrary to this, according to me, they are covered by this.
Right.
You file it next week. Give next week anytime.
Can it be, my lords, either on Monday or Thursday, my lords, or Friday?
It won't take much time. Thursday. You just see these notifications. Sir, please give the notifications.
Yes.
He may not have that.
তিনটা copy দিয়ে দিন।
তিনটা আপনি যদি দেখছেন সেটা দিয়ে দিন তো তারপর দেখি ঠিক আছে
I am giving that. I just.
Yes.
Circular.
What
do you mean?
Question number জানছিলে আমি
70. Pardon, my lord.
Item 70.
Pardon, my lord. Item 44, my lord. Item 44. My lord has fixed to 11th May, my lord. It will be early, my lord. Item 44, my lord. Item 44, that pass over.
I think the month or year.
No, my lord. My lord.
What is the urgency?
Vigilance case, my lord.
Difficult. Yes.
70.
Item 70, lordship, on behalf of Mr. Sahu, I pray for pass over, lordship.
Pass over.
After notice pass over.
Then lordship will call this next week.
Urgent. Why do you ask pass over?
Because he's on legs before Hon'Ble Court note. So he requested me to put a pass.
Let it be because today is.
As you, lordship.
71.
That's all, lordship.
71. Nobody there. Last date में कोई नहीं था. Adjourn to August. Nobody there.
Case for question of cognizance, but charge sheet has not been filed.
Let it come on August.
No, I think 72 somebody mentioned in the first hour, but actually there was a personal appearance. It will count.
Nobody there.
72. There was a personal appearance. What mentioned for Arjun.
Okay, on request.
Well, 74.
My lord, in this case, there is a noting that about the defect, and on the last date, admittedly, my lord, I had sought time for removing that. For pressing personal difficulty, I have not been able to do that. But however, I would say, my lord, there are two defects. One is 3 rupees.
Whatever defects
My
are.
lord, I will remove that.
Then council for the petitioner seeks time to remove the defect within a week. Okay.
Obliged.
Do it.
76.
Yes. Notice to opposite party number 2. File करते देखो तो ये process हो रहा है.
जो तो 76.
76.
Parking report.
Item returned, addressee left without instruction.
That can be treated as a sufficient. The judgment is not sufficient. Addressee left for. The judgment be the judgment. The notice was issued to opposite party number 2 by the order dated 11/3/2024. The track report indicates that the addressee has left without what is it? Without instruction. Without instruction. As per the law laid down by Supreme Court in such and such, and the service is treated to be sufficient, and in the interest of justice, matter is adjourned. Yes.
77.
None appear for petitioner report.
On behalf of Mr. Jagavant Sarma, kindly go 2 weeks.
Adjourned.
Interim order is
Obliged.
78.
May it please your lordship. My lord. My lord, 78.
You are not well or what?
I am.
You are very.
No, my lord says actually that is not required. Kintu parking ଜାଗାରେ ବହୁତ ଧୂଳି ଉଡୁଛି ସେଇଥିପାଇଁ just I am ସେଟା ସେଇ ଜାଗାରେ ବେଶୀ ଟିକେ dust ବେଶୀ ହଉଛି for that.
You have to acclimatize with the
With that to be acquainted. Okay.
Yes.
My lord, the petitioner is the accused. This is a check bounce case 138. The petitioner challenges the order passed by the London magistrate under 143A. Your
You are the accused.
I am the accused. And these facts and circumstances, your lordship, my lord may consider that the magistrate may exercise the jurisdiction as has been said by Honorable Supreme Court in Rakesh Ranjan Srivastava just 15 days before. That the magistrate may also exercise to decline to grant interim compensation. Because the nature of the case is like that, your lordship.
It is again discretion.
Discretion, your lordship. I am just.
So, if a court has exercised discretion,
my lord,
how can I say that the discretion is wrong or right?
If from the record, your lordship, it appears that the discretion has.
Does it say that at this stage of awarding interim compensation, I have to go into the merits of the case?
With respect, my lord, the judgment I am placing, my lord, therein Honorable Supreme Court has placed few guidelines. If your lordship will permit, my lord.
So me.
Take it again.
Yes.
My lord, I'm just reading the last but one page. Where they have, my lords have summarized it.
Court have to evaluate.
Yes, the broad parameter.
That's what I was asking. Correctly, Supreme Court says that you have to evaluate prima facie case also.
Yes, your lordship.
That's right.
And the defense plea
taken by the accused will also be taken into consideration. My lord, what has happened in this case, your lordship?
I understand. Now you should tell me what is your case.
My lord, the complainant says she has given me 5,50,000 as such. No mode of delivery, no account transfer, nothing. She says that I have given 5,50,000 as if it is cash. And I could not return. This is her case, my lord. And the mode of payment, nothing has been settled. How she paid, nothing. Then she filed a petition under 143A to award interim compensation. When the learned magistrate awarded 20%, which is maximum. Now, in this case, before your lordship, the Honorable Supreme Court, wherein 5% was awarded, that also Honorable Supreme Court caused that whatever may be the quantum, the learned magistrate has to apply mind. Now, my lord may kindly see what has in fact happened, your lordship, that I have stated clearly in my objection to that petition at page 23. In fact, I have no liability.
You have replied to the statutory notice.
Replied to 143A in detail.
No, statutory notice 138.
138, my lord, I have appeared.
138 statutory notice.
Oh, statutory notice. That I have replied, man.
Replied?
Yes, sir.
Where is that for me?
No, say it next. 143 petition.
If you have not replied, then the presumption operates.
Yes, sir.
Then in that case,
that also, my lord, the Honorable Supreme Court said.
Where is that in the guideline?
My lord, I am reading the last paragraph. It will clarify everything. This 139 may not be
broad parameters.
But the broad parameters last but one page. The court will have to prima facie evaluate the merits of the case made out by the complainant and the merits of the defense pleaded by the accused in reply to the application. The financial distress of the accused can also be taken into consideration. A direction to pay interim compensation can be.
This is the law. Again, the regime was the earlier regime. Earlier regime wherever there is a condition of pre-deposit.
My lord.
Then prima facie case and financial distress
to be taken into
consideration. You have to consider.
Your lordship may kindly consider my condition. Page 23 I have annexed. Page 23 of the read of the CRLM's petition. Absolutely, again, more liability किछ नहीं.
नहीं इधर देखो ना यदि if you have not written replied to the statutory
my lord
notice,
my lord,
what will be the
my lord? Then I am reading, my lord. A direction to pay interim compensation can be issued only if the complainant makes out a prima facie case. If the defense of the accused is found to be prima facie plausible, the court may exercise the discretion in refusing to grant interim compensation. If the court concludes that a case is made out to grant interim compensation, we will also have to apply its mind.
Just I'll if you notice. What is the check amount?
My lord, the difficulty is that your lordship may not stay. Let the case proceed, but the operation of this order may only be stayed because the learned lower court is saying that unless you pay it, it would be recovered like a fine, your lordship. So again, the distress warrant and NBW is to be followed. The check amount is 5,50,000. What has happened, my lord? We are known to each other. We have both started a coaching institution. Now, in the coaching institution, when it grew up, there was a plan to open a new branch. It was agreed that 14 lakhs is to be the capital fund. 60% I will pay, 40% she will pay. So 5,50,000 she has invested. 8,50,000 I have invested. This is paragraph 12 I am stating. That is the reason, your lordship, she is not saying the mode of payment and everything.
How the check has gone to her?
She said that I will invest, but you issue me a security check. Unless you give me a security check, I will not invest the money. You issue me a security check, thereafter only I invest.
She was your partner.
Partner, your lordship. When there is a business law, now, my lord, in COVID, the worst affected area is the academic field, your lordship. All the coaching institutions, many were ruined even. Now, I suffered loss in that.
The story is
that your lordship, at this stage, 143A, when I am objecting, that may be taken into consideration because the defense plea appears to be plausible that the honorable court will consider.
How is this plausible? You are for 60-40 partnership.
My lord.
You have paid 88 lakhs, he has paid 5 lakhs.
5,50,000, I have paid 8 lakhs.
Profit.
We both suffered loss, my lord.
Then where was the occasion for you to give a security check?
That she insisted that I will invest 5,50,000 only if...
Is it not sounding unreasonable or sounding not plausible at all?
I have no other option, your lordship, because I need some money. She said I am ready to invest.
Then why have you made her 40% partner?
My lord, I have stated it in paragraph 12 of my objection.
So that this defense itself is not plausible.
No, I agree that she has invested money therein. But if it is a business investment and loss is sustained, my lord, I may not be blamed for that. And only thing is that, your lordship,
Both of you were running a coaching institute.
My lord.
He wanted to,
My lord,
he
the
wanted
fact
to
is
start
that-
a new,
my lord.
coaching institute somewhere else. And decided that about 12 lakh will be the expense.
14 lakhs would be invested.
14 lakh. And you paid 60%, she paid 40%.
Because I
And the loss gain, whatever you will share in that ratio. Where is the question of giving a security to that?
Because I was the owner of the earlier institution. So since I am the proprietor, she said that I would agree to be a partner only if I am assured. I cannot pay you money as such. You open a new branch, I will be a party to it. We'll carry on it. But I must be assured. That is
where, is there any agreement to that effect?
No, madam. That I have not said.
This is story built up by you.
That I have stated.
You have to establish that story. This story has to be established by. Show me any document.
There is no document. Your
Then you have built up a story.
That is
and you want that the court should believe the story. And the statutory requirement of payment has to be denied.
That is so far the statutory requirement is concerned. Your lord.
I can only issue notice to help you.
That
No question of any interim order. I don't.
My lord, the difficulty.
Case is not
The difficulty is that now this amount is not to be. If I am not paying it, what will happen, your lordship? I am reading it, your lordship. That is 143A makes it clear. I bow down, my lord, may say that let this case proceed. I have no objection. Let this, because she has already filed her examination in chief. So cross examination I have to do. I'll do that, my lord. I am not objecting. Only the operation of this order may be stayed.
Will you settle?
My lord, I will settle, my lord. I have even no objection. If your lordship says that I will deposit 10% and dispose of the matter, I am ready for that, your lordship. The amount is
10% you will give, the entire case will go.
No, my lord. 10% I will deposit under 143A under this order. If your lordship will say 10% I will deposit, I'll deposit, my lord.
What is the amount?
20%. That is, I am even two factors. First, whether it should be awarded or not.
Right on. Issue notice to opposite party number 2. Written within so and so. Where is that order? Impugned order?
That is impugned order under Annex 4, page 27.
Subject to 27. Subject to petitioner depositing. What is the 20% amount?
20% is 1,10,000.
Then 50%.
1 lakh has been directed. In fact, 1 lakh has been directed.
Subject to petitioner depositing 50,000 rupees to begin with, without prejudice to right and contention of both the parties. Operation of order dated 3/10/2023 is said. However, it is made clear that the trial should proceed at its own pace. Take it. 50% deposit. At least you should give it to me.
Your lordship may kindly give me some time, man.
Subject to paying 50,000 rupees within 15 days.
I must have 1 month again.
But 50,000 rupees, what you are appearing means the effluency of this client can be seen.
Hey, what amount he has paid to me, if I'll tell.
Don't tell that. That's a privileged communication.
Then your lordship will
15 days is enough.
Your lordship will feel pity for me. So
no, nobody will feel.
Mate agya May 15 jaye diyon. May 15 jaye diyon.
15 honor before 15.
Obliged.
Next, when is the next date there?
Next date is there, your lordship. Since your lordship has permit.
Yes, that will go in. Okay. Yes.
79.
Question of FIR, my lord. Your lordship, last occasion on
Madam,
3.
I am going to appear for the informant. So now
What
I'm
happened?
the vocal now, file now. For the informant.
Informant.
Your lordship.
Also to enter appearance.
So till now, it has not made the party.
And what is
So
the
kindly
stage of
solve
the
the copy and
investigation?
file the objection.
My lord, just I have some. Your lordship, on previous date, the police paper, your lordship has called for the police paper under 173 CRPC, my lord. And your lordship also directed me to submit documents, previous enmity. I have also submitted the.
Hey, I have last time I said to awaiting the report of 173. Have you filed that?
No, my lord. I have not obtained.
My lord, in the meantime, my lord, what happened, my lord? The father of the petitioner 1
is a cancer patient, my lord. I have annexed, my lord, that document, my lord. And author bodhe thibo sethi. See, jehetu police is running after them, they are not unable to admit again at SCB, my lord. Whole difficulty is there, so some respite is given to them, and there is chance of.
You have filed this petition seeking quashing of the file.
My lord, my
Investigation is going on.
my.
And you have submitted all these things. Therefore, I just wanted to know whether charge sheet is filed or not. Once charge sheet is filed, then we'll see what are the measures.
Short adjournment may be
Therefore,
allowed to me.
what he says is, see, one of the petitioner is a cancer patient.
No,
Each
no,
father, my
father
lord.
of the
Each
petitioner,
father of
and
the
this petitioner one.
Father is not an accused.
No,
actually,
father is not an accused.
It's a cancer patient, my lord. I have annexed their documents.
But he's not accused.
No, my lord. What happened, my lord?
No.
The only male
He's
member.
taking that plea for getting this.
Only male member is the petitioner one, and petitioner two is the son-in-law, my lord. That's why your lordship grants some treatment. Just have a glance, your lordship. At the
No, am I considering the bail, please? Am I considering the bail?
Well, I have only for few days, my lord, for admission.
Try to be reasonable.
My lord.
I am exercising 482.
My lord.
You have asked for quashing. Investigation is going on. Last time I asked what is the stage of the investigation.
My lord.
Please inform. Investigation is complete or not, he doesn't know. You want bail in this order. How can I give it? And you say that the two accused, one of the accused father is a cancer patient.
No.
Therefore, you want
this petitioner one and two is father and
maybe
son.
whatever.
Their father only he's staying at their residence.
You file appropriate petition in appropriate court and tell all these things so that you will get the protection. Not this.
What happened? Just 15 days or 30 days, my lord.
Sorry.
My lord, extreme heat wave is going on.
You are right. All humanitarian considerations are there, but I have my own limitation in this procedure.
My lord, just have a glance at.
Then I am rendering the 438 and everything.
No, that.
If I start entertaining everything.
No, my lord, no. Then, what happened, my lord?
And what have you filed? Except a copy of FIR, nothing.
My lord, your lordship, that's why on the previous occasion, your lordship was directed to file the document. I have filed, there is another
rejected bail also. Honorable court.
I have also, there is a GR case I have filed, my lord, in which that informant is accused. That
is a previous case.
And there is also RP case, my lord. And
all these things you have
but it is a separate case.
Yes.
You give it to police. Police have to look into it. I'm not the investigating officer. I'll analyze all these things sitting here.
There is a chance of compromise, my lord.
You tell them, bring them here. I'll watch it immediately.
What happened, my lord?
No chance.
Give me, your lordship. Give
no
me
chance of compromise. He
Your
is threatening to him. Just now he's on a treatment now.
My lord,
he taking medicine.
Your friend is there with you.
My lord, all the avenues has been closed, my lord. And that's why I'm.
No, 438 is there. You file application.
No, 438 rejected, my lord. Whole difficulty is there.
I wanted to know that only.
My lord, that's why it's coming to get
your
the
lordship is the best court and
Can't see.
few days, my lord.
Now your case is worse. If the 438 is rejected by some other court, I am allowing you. That means I am superseding that order.
What I'm
How can I do it? Try to be reasonable.
No coercive action till the
I can't
till
pass.
admission.
And I'll only request them to don't take. Mr. Rahul, tell your IO not to take coercive action.
Yes, my lord.
Well, that's
This is the request I am making him. He'll tell the IO. 1 minute. He will tell the IO because of the health condition of your father. He will just request the IO not to take coercive action.
observation.
No, I can't do that. Please try to understand. I am requesting you and respect to the prosecutor. If the court is requesting, I will definitely do it.
I'll do it.
Please,
arrest
I will intimate.
On your behalf, I am requesting him.
That before it was
Please
rejected
respect
also.
his words also. And
Yes, ma'am.
please tell
Yes,
the cancer patient.
Yes, my lord. Yesterday I have done also in another direction of your lord.
Tell that the court desires that.
Yes,
don't
my
do
lord.
it. Be happy with it. Yes.
Before that was a rejected matter. This honorable court.
Try to be a little, compassionate also, because the father of the petitioner is a cancer patient.
Somebody
he wanted
in-
to get him admitted in the medical
operation
this thing. Because of the threat, he is not able to do it.
Somebody is necessary to give this service.
So therefore, judicially I can't pass the order, but we can
Yes.
request very well.
Yeah, I will intimate to the concerned IAS.
Your
No
friend
problem.
will also request. Don't
Yes.
worry. Your friend is there. He will also. Yes.
Threatened those in Asifar.
Take it. Yes. Item 80. 80.
I am at PC, my lord.
Just pardon, my lord.
My lord.
Maybe common who's
He'll give it. Yes.
Let us say paragraph 16 is just like the presumption under section 139 of NI Act by itself is no ground to direct for payment of interim compensation, which your lordship has asked me.
That is there.
That is paragraph 16. The
Anyway, I passed the order.
my lord, only your
That is a very important thing.
that your lordship asked me. I immediately.
Which paragraph you say?
Paragraph 68 again. Paragraph 8 again highlighted. Paragraph 16.
Judgment mat do.
Again. Paragraph 16.
I'll utilize this judgment for other cases. Na?
The
39, na?
Paragraph 16. The presumption under section 139 of the NI Act by itself is no ground to direct the payment of interim compensation.
Okay. Because I have been taking a view contrary to what the Supreme Court has said. I have been taking the view that once you have not replied under 138 NI Act statutory notice, the 139 operates. Therefore, 143 is automatic. That was the view I had.
Again,
But now,
very recently, 15 days before this judgment.
so therefore, I'll have to change the view now. Yes. Item 80.
I am at a BSc, my lord. This matter may taken up after 2 weeks, my lord. Take instruction whether it is a conditional order, whether
Yes,
he has
2 weeks.
deposited. Yes.
Yes, sir. Yes. 2 weeks. Yes. 81.
May I please, your lordship? May I please, your lordship?
Yes, ma'am.
Lordship, in the present case, the defect number 22.
What a cure.
Your lordship, the registered directed us to require the same with permission from this honorable court.
What is
With
that?
permission.
What is the defect?
Your lordship, name of one of the accused, one of the petitioner has not been mentioned in the petition due to inadvertence, your lordship.
No, I'm not. I didn't follow you.
He has signed in the Bakalatnama, your lordship.
You don't have the Vakalatnama, one of the petitioners.
Your lordship, in the Bakalatnama, the petitioner has signed. However, due to inadvertence, we have not mentioned his name in the petition.
There are 3 petitioners,
Your lordship.
but you have Vakalatnama 4.
Yes, your lordship.
That's what you want. Complete. 4 of them have instructed you to file.
Yes, yes, your lordship.
Wherever you, unfortunately, you file 3.
Yes,
Want to
sir.
add one of one.
Yes, your
You
lordship.
do it.
We'll do the same.
The petitioner is permitted to a few of the defects as pointed out by SR. We can, but give in typing. See, you are what kind of handwriting you are writing, nobody can read you. If they can't put
We'll do it.
type and go. And see, petitioner number 3 also, I don't know who is the father, who is, what is the address.
We'll submit a written.
How many corrections? Type it and give.
Yes, lordship.
The entire both the state. Yes.
Oh, bless.
82.
My lord, extension of time of surrender, my lord.
How much time?
1 month. Your lordship, in earlier, in similar case, your lordship granted
No, I asked you to surrender before
15 to 2020.
Huh?
15 to.
No. No, on or before
15.
7th March. 7th March 2024. The order dated 16 to 2024.
My lord.
Oh, I have given 7th March.
7th March only.
1 month time.
7th March now you are coming. 7th March time na. 7th May kar diyo. 7th May? 15th May. Okay.
30th.
March I had given. April gone. Now you are approaching May. 15. Again, see, Mr. Maharaj, again he'll come and ask time. Better that Make it 30, 30th May. No further extension. It is made clear that no further extension will be given.
Until no cross-checks.
Huh?
No cross-checks.
NBW asked for cancel. I have cancelled. I gave the time. You have not appeared. After expiry of that time, you move an application for modification and extension. Now you want no course. Before asking something, do you realize what you are doing? I will not give you extension also. Please don't misuse the jurisdiction. Try to be within a limit. 30th May. It is made clear that no further extension shall be given, and the NBW issued against the petitioner on 17/8/2023 shall be executed forthwith.
83.
May I please this your lordship?
Yes. Yes. Yesterday it was there, huh?
Yes.
Your lordship, yeah, your lordship, I filed this IA, but unfortunately I missed the order to annex in this.
It's all right. What do you want? I forgot what you.
Sir,
said yesterday.
sir, I want extension of time.
para 3 ଆଉ 4
para 3 ଟା extension कर देले हेलो
para 3 रे कोटा extension के दिन
13th March.
मार्च थिला 30th May कर दो आको
30th May कर देले हेलो
मार्च थिला ना 30th May कर दो
para
okay
3 and 4
4 also he wanted to express but he was not able to do it
सब जगह से 30th May
कर दो ठीक है
सब जगह 30th
okay allow
Oblige, your lordship.
84.
yes 84
Extension.
extension of time surrender data extension होगा
extension of time 20 April थिला 20th April थिला तो तारे 30th May कर दियो
30th
तापर लिखी दो it is made clear that no further extension will be given do extension do to make it that no further extension will be given and the NBW issued by the court below on 23/7/2009 shall be executed forthwith.
Yes.
85.
Lordship, in this application, in this case, we have filed an interim application, Lordship, for modification of para 3 and 5 of order dated 5/4/2024.
3.
Yes, Your Lordship, 3 and 5, wherein the date of NBW is wrongly typed out as 4/1/2022 instead of 4/1/2024, Your Lordship.
4/1/24. Okay.
Yes, Your Lordship.
You got that? Amit.
And Lordship also read for extension of surrender.
The order dated 5/4/2024 in para 3 and para 5. 4/1/2022 लिखा है 24 होगा ठीक है 4/1/2024 ठीक है
And Lordship, extension of surrender date also.
In view of this conclusion, the petitioner could not surrender before the court by 30th April 2024. Hence, the time for surrender is extended to 30th May. 30th May, and made clear that no further extension can be given in case of for
Grateful.
86.
Carefully.
So far as the past IA is concerned, that is for the modification of the order dated 10/4/2021. Inadvertently, number 420 has been added, though the learned court below has taken cognizance under section 500 and 506. So 420 is to be deleted now.
No. The petitioner is telling the order dated
Para 3
or 3 or 3 na? Where is the cognizance order?
Cognizance on dated 5/3/2021. Says 12 my lord of the
Complaint taking cognizance.
CRN actually like 60 or
Acha, acha. And the cognizance is, acha, complaint is 420, 500 and 506, but cognizance is taken. Right.
500.
Yeah, in the order dated 10/4/2024, in para 1, only in para 1, na?
Man.
In the para 1, para 1, and the para 1 is made clear that trial court by documented or taking cognizance of offense under section 500, only 506 IPQ and 5 IPQ or 420 will affect you for 9.
My lord, so far as the second IE is concerned, I have filed for the return of the entire certified copy of the order because that is
IE number?
IE number 915.
915
of 2020.
IE number 915. The IE is allowed. The certified copy of the what? Certified copy of?
Return of certified copy.
Certified copy of the entire order sheet at annexure 2. Or may be written to the receiving director to return the certified copy of annexure 2 or to the petitioner by substituting the photocopy.
Oh, bless me. Madam, my lord, item 84, my lord.
Extension of time.
Extension of time also, my lord. Para 5, my lord. The lordship, my lord, passed by Lord Session Judge Puri, STGM Bolangir ମଧ୍ୟ ଲେଖା ହେଇଛି। STGM Bolangir ଲେଖା ହେଇଛି।
STGM Bolangir ଲେଖା ହେଇଛି।
ସେସନ ଜଜ୍ ପୁରୀ ଠିକ ଅଛି, ପୁଣି STGM Bolangir ବି ଲେଖା ହେଇଛି।
କାଇଁ କୋଉଠି ଲେଖା ହେଇନି?
ପାରା 5 ରେ ମାଇଲର୍ସ, ଅର୍ଡର୍ସ ମାଇଲର୍ସ। STGM Bolangir।
ପାରା अरे पूरी एंड एसडीएम बोथ
STGM पुरी नो खाली सेशन जज पुरी माइनस
सेशन जज पूरी ते लिखाई तापर वो एसडीएम काई लिखाई
STGM Bolangir
5 पारा 5 84 आइटम 84 में पारा 5 रे एसडीएम Bolangir 40
and also extension
89 oh here I don't know. I can't bring everything. Every day there are paragraph sections and all. Every day. Still there. I can't trust them.
Madam, we pardon 87. Arjun.
Yes.
Madam,
Generally, what happens is the case number, cognizance and all, they are supposed to check it from the record. It is humanly not possible to check. Humanly not possible. If 100 meter, if I'll keep checking the sections and dates and all, you can't proceed at all. And you have to trust someone.
Possible.
What to do?
Possible.
Computer.
And every day there are 3-4 applications for modification.
Computer
But still, you can't have excuse. There judicial record. If you pass a small mistake is there, trial court will not allow. Somebody's liberty is at stake. And we can't say that computer has committed mistake or who has committed mistake. Ultimately, the accused is suffering. That's the very important. So therefore, one has to be very careful.
Madam, I may pardon 87. Business case. I have filed stay of conviction and also filed paper. The business counsel has taken time.
1 minute. We are in which matter? We are in 89.
87 day. The business standing has taken time. I have no objection, but I have filed a stay of conviction. The authority is going to take out his service unless he is dead. And also, simultaneously I filed paperwork for hearing. So, in his presence, order passed tomorrow or next week.
Beyond suspension of sentence, Nothing can be given to you. You know that.
Yeah, I know.
You will waste time, half an hour, you will argue, I'll write a judgment, I'll reject your argument.
2001 Supreme Court cases.
Who is paying conviction?
My lord,
In
2001.
a prevention of corruption case.
But I pray one thing, I filed paper that may be accepted.
You can very well say that I'm ready to argue the appeal, I'm ready to hear the appeal.
Yes,
You convince the other side, I'm ready to hear.
Let it
If
come
you
to my in his
are entitled for acquittal, you will be acquitted.
In his
Don't ask
presence-
for stay of conviction.
In his presence, that order is to be passed. Since he is not there, let it come tomorrow. It will be
No,
accepted.
you tell him and bring him. He is there, I mention it, I'll take it up.
Mr.
Final hearing, no problem.
My lord, I have pardon, paperwork is to be accepted, then.
I told him that instead of paper book, the soft copy is already there.
I have already filed paperwork.
Paperwork is there, then we'll exempt that. If you don't rely upon anything else.
Good.
See.
There
Call
is-
him, call
there
him.
is
Yes.
My lord, I may pardon, let it next week, I will convince him.
You call him and mention it. I'll take it up. Yes.
Lordship, there is second item also there in the matter. Tag matter is the Lordship. No, 87.
Call,
Their
mention it.
paperwork is to be prepared.
Huh?
Their paperwork is to be prepared in my case because there is.
That's the problem.
That received that.
I have already passed the order, we'll see. What?
Yes.
Yes, 89. 89.
May it please, Your Lordship. Your Lordship, I am appearing for the opposite party in this case. The, my, Lordship, the petitioner counsel is in
Somebody
VC.
is waiting.
Is in VC. Let him continue.
Yes, yes. Yes, Mr. Pujari.
Let's say the petitioner hereby seeks for quashing of the affair that which the present case has been instituted basing upon a complaint petition which was filed before the learned court below. At the outset, the petitioner humbly submits that directly the petitioner has the opposite party number 2, who is the informant complainant before the court below, has directly approached the court below without complying the section 154(3) of CRPC. At the outset, before filing any complaint before the court below, first of all, he has to give the written report before the police station concerned, and on refusal for registration of the affair, the complainant has to approach the concerned SP or the DCP. In the present case, the DCP under section 154(3) of CRPC, ventilating therein his grievance that the IAC concern has not registered my case, though the written report discloses the cognizable offences. I am relying upon the judgment of Honorable Apex Court in the case of Priyanka Srivastava Lordship. In this case, I have also filed some judgments before this Honorable Court today, Lordship, some bunch of judgments. Basically, I am relying upon the judgment of Honorable Apex Court in the case of Priyanka Srivastava Lordship that I have quoted at page number 5, paragraph 9, my lord. Paragraph 9, page number 5, my lord.
Yes.
Lordship, the Honorable Supreme Court has clearly observed that in the second paragraph, in our considered opinion, a stage has come in this country where section 156(3) CRPC applications are to be supported by an affidavit duly shown by the applicant who seeks the invocation of the jurisdiction of the magistrate. That apart, in an appropriate case, the learned magistrate would be well advised to verify the truth and also can verify the veracity of the allegations. This affidavit can make the applicant more responsible. We are compelled to say, so as such kind of applications are being filed in a routine manner without taking any responsibility whatsoever, only to harass certain persons. That apart, it becomes more disturbing and alarming when one tries to pick up people who are passing orders under a statutory provision which can be challenged under the framework of said act or under Article 226 of the Constitution.
All right, come to page 9 of the complaint.
Page 9.
Affidavit is already there.
Affidavit there, my lord. He is not disputing the affidavit, my lord. He is disputing the fact that whether that is column number 6, my lord, page 13, my lord. Whether any information lodged at the police station.
He says that 154(3) is not complied.
And
Therefore, you can't invoke 156(3). That's what he says.
That is his assumption. But to that respect, my lord, on page 14, column number 6, my lord.
Page 14, huh?
My 14. And column number 6, my lord. Whether any information lodged at the police station, yes, but the concerned PS did not take any action, and on one police personnel of the concerned PS advised the complainant to take shelter before the court of law. For that reason, my lord, he had filed the complaint case before the court of law, my lord. That are another thing, my lord. He is disputing the fact that relying the Apex Court judgment, my lord, He's saying that, my lord, the complaint must have lodged information to police station and so also give information to the higher police officer. So, my lord, I am reading out three, my lord. Suppose three, my lord. 153. Any person agreed by a refusal on the part of the officer in charge of a police station to record the information refer in subsection 1 may send the substance of the source in, may, my lord, may send the substance of such information in writing or by post to the superintendent of police commission, superintendent or commission of the cognizable offences, my lord. But here, my lord, there is not, my lord, it shall not be may, my lord. Not by technical grounds, it cannot go, my lord. Right, to send on 156 of 3, my lord.
Yes. In fact, the statute clearly says that I am very fairly submitting that may submit the substance of the information before the higher official. But thereafter, in the year 2015, Honorable Apex Court has clearly observed that he has to categorically spell out that yes, I have when such now what constrained the present petitioner to invoke this the jurisdiction of this Honorable Court that after 1.5 months, the present case was instituted against me. When I have been instituted.
Yes, you are appealing for opposite party.
Yes.
Yes. What is it?
My lord, my learned brother has already clear, your lordship, I think. And the statute is very clear. The word may is used. He or she may approach the superior officer with regard to the substances is concerned by post or by giving it hand to hand. So when the word is very clear, the word may is very clear. So there is no ambiguity at all. And rightly, we have preferred the complaint case before the magistrate. And one thing is that the Lalita Kumari case, your lordship knows it very well, where it is mandatorily the duty of the police officer to register an FIR in Lalita Kumari case. It has been already settled the points of law in the Supreme Court.
But the affidavit is filed.
After my
Para 31 of the judgment which he is relying, that also it says that you have to give in affidavit saying that you have
affidavit is there. If you will verify those judgments, several judgments, where the Supreme Court has categorically said that with regard to hammering with regard to the affidavit is concerned, because the affidavit has to be filed by the complainant to be conscious. For conscious. That is what he has contended in his petition.
After what I want to submit, lordship,
on the Babu Venkat's
it is not a mere formality.
That is
Lordship, what I am trying to submit, lordship, affidavit is not a mere formality. In the Priyanka Srivastava and in the subsequent judgment in the case of Babu Venkatesh, Honorable Apex Court has clearly observed that in that affidavit they has to clearly spell out that yes, I have completed the 154(1) as well as 154(3). Simply filing an affidavit does not entitle the complainant to institute the complaint case against me. They have to mention in that affidavit, yes, I have lodged the written report before the concerned police station, and on the refusal, I have also ventilated the same before the DCP concerned. They have to categorically mention in that affidavit. Otherwise, the affidavit is merely just a piece of document, lordship. And even if this honorable court has also, in the case of Snigdha Mahanti versus State of Orissa, reported in 2023 Part 1 ILR, also relied upon that judgment, Priyanka Srivastava lordship. In relying upon that judgment, honorable.
In that case, affidavit has not
I have
filed.
the council, state council refers coordinate wise ballot. That case, the affidavit not filed. That for that in this.
Yes, in that lordship, may I be permitted to place those language that language is that Supreme Court held that a decision for police investigation in terms of 156(3) CRPC is not an empty formality, and there has to have judicial application of mind, and the magistrate for the said purpose should ensure that the complainant has taken recourse to section 154(1) and 154(3) of CRPC, and an application under section 156(3) CRPC must be supported by an affidavit by sharing details.
I understood. Right on. Right on. The petitioner is challenging the entire. Petitioner is seeking quashing up for the ICC, the FIR. FIR being Nandankaran PS case number so and so, Nandankaran PS case number
102 up to 22.
of 2022, which was registered pursuant to the direction of the which court direction?
JMFCO Bhubaneswar, Lordship.
Direction of which court direction? 156.
AMFCO.
Pursuant to the direction of JMFC Bhubaneswar, while its order dated 8/7/2022 in ICC case number 4000 of 2022. The Mr. Pravas Pujari Parida, and counsel for the petitioner submits that the direction of the code below under section 156(3) CRPC for registration of a FIR is not sustainable under law because it is making judicial application of mind as the complainant has not followed the procedure under section 154(3) CRPC and has also not filed appropriate affidavit required under law and mandated by the judgment of the Honorable Supreme Court. I peruse the copy of the complaint which is placed on record. Where is that complaint?
Page
Here.
13 from 13.
The para 6 and 7. The para 6 and complaint. Reads as under. Reach out. Next product.
And affidavit page 18.
I was reading somewhere else. I was reading somewhere else. Copy. Yes. Yeah, page number, page 20, 25. 25 page 25. Petition page 25. Para 6 and 7. The reading of the above two paragraph indicates that before resorting to the procedure of 156(3) CRPC, the complainant had given written report to the police of to the Nandankaran police station, Bhubaneswar, but the police personnel refused to register the FIR and rather advised to take the shelter of appropriate court of law. This declaration of law is being supported by the petition, supported by the complaint through an affidavit, along with the affidavit, and which reads that the facts stated, the facts stated above are true to the best of my knowledge and belief. Therefore, the twin condition required to be followed before resorting to section 156(3), that a declaration regarding the complainant approaching the police before filing the complaint and a affidavit and a supporting affidavit in the complaint has been done in the present case. Therefore, the submission of the petitioner factually is not sustainable and sustainable. The judgment relied upon by the petitioner in the case of Babu Venkatesh and others versus state of Karnataka and others will not come to the aid of the petitioner. Hence, the petition lacks merit. Accordingly, it is dismissed.
Lordship, may I play only one thing, Lordship? My humble submission is that they have not complied the 154(3). Even their affidavit does not substantiate anything that they have complied 154(3). My humble submission.
Okay, I have taken a view. If you are aggrieved, you have a remedy. Yes, next.
Oblige, Lordship.
90.
Previous. What is this? joint affidavit filed, everything is there.
But last of the urgent, but the advocate for the petitioner assured that he will bring the opposite party and compromise matter. For that reason, my lord, it was in the list on 9/4 and urgent to today, my lord. But nobody is appealing.
What is the offense?
420, 460, 471, 474, 34 bytes.
Write down. No, on the last date of hearing and on 9/4/2024, none appeared for the parties. Even today, nobody appears. Nobody appears. Why we have lost opportunity? My colleague is going to next week we will discuss further. It will make clear that no further adjournment is necessary. Yes.
91.
May I please, your lordship? Lord, in this case, the order of cognizance is not a challenge, my lord, but the case is now settled out of court.
Yes.
Your lordship may pass it over for up to 4 p.m. The petitioners and the affected victim is present and affidavit is going to be ready.
Today,
If your lordship permit me, then
no, today it may not be possible because
yes, your lordship may fix up a date.
I have a
Yes, I can't go beyond your lordship's arrangement.
fix tomorrow.
Yes, ma'am.
Bring tomorrow.
Yes, ma'am.
Tomorrow.
Highly obliged.
What is the offense, by the way?
My lord, this is the case is outcome of a business transaction. What a 25,000 ଜାଗାରେ ସେ ଆଉ ଜଣକୁ 14,000 ଦେଇକି ଜିନିଷ ଉଠେଇ ନେଲା 364 ଏ ଚାର୍ଜ ସିଟ୍ ହେଇଛି
No problem. Bring tomorrow.
tomorrow. Highly obliged.
92.
One limited questions required adjudication before Honorable Court. But in a complaint case under 138 Act, where the complainant has to file. In the particular case, madam, the check was bounced under the jurisdiction of Bhubaneswar. Notice was issued under the jurisdiction of Bhubaneswar. So as per 142 subclause 2 of NI Act, the complaint is only to be filed under the jurisdiction of Bhubaneswar. But instead of that, if the complaint was filed at SDM Khorda.
Where the check was deposited?
Pardon? Bhubaneswar. And my lord knows the government of India through a law, they made it change it, giving 5 places where it can be filed. Now it has been no more a good law. Now it has been set aside, and this Honorable Court and this after amendment of 142 subclause 2, it only empowers the court wherein the check has been bounced to be the authorized court to file the complaint and to enter the complaint, vis-a-vis to proceed accordingly. My lord. In the particular case, this is a case where the case has been filed at Khorda, who has no jurisdiction. That is the only ground which I have urged before the Honorable Court. And there is a direct judgment of the Honorable Court after this controversy.
That's a secret judgment.
No, of this Honorable Court. That is secret, my lord, justice secret judgment is there. Taking note of that, 2070, volume 2 OLR, 768, the Narottam Basir case, it has been held by the Honorable Court that, yes, in fact, where the check has been bounced, that has been presented, in that is the only jurisdiction.
May I please, your lordship? I am for the opposite party in this petition, my lord. Your lordship, kindly have a glance. The affidavit filed by me.
Yes.
In the present case, the petitioner challenged the order of cognizance dated 39/2021. Now pending in the file of JMFC Khorda. So far as the facts of the case are concerned, the opposite party, both the petitioner and the opposite party resides in the village of Malipada in the district of Khorda. The opposite party has filed 1cc case before the London SDG of Khorda on 8/6/2021, and cognizance was taken 39/2021, followed by appearance of petitioner and his personal attendance was dispensed with. After lapse of 1 year and 2 months from the date of cognizance, the petitioner filed a petition before the Learned Court below on 14/11/2022, questioning the maintainability of the complaint petition. After hearing the parties, the Learned Court below rejecting the prayer of the petitioner with an observation that the opposite party will file the 1cc case on 8/6/2021. Cognizance was taken on 39/2021. followed by appearance of the petitioner and his personal appearance dispensed, and also observe that 1cc case of 2021 has filed after transferring the account to Khordha from Bhubaneswar, and statutory notice was also issued from Khordha. Now the case is at hearing stage. Accordingly, the petition filed by the petitioner rejected on 12/12/2022.
Now the account is in Khordha.
Yes, my lord. Which has been suppressed by the petitioner in that petition before this honorable court, and that order has not yet been challenged.
Which one?
That order, your lordship, annexure A/1. Annexure A/1.
Cognizance thereafter this order. I have challenged order of cognizance.
No.
No, what is your
Annexure A/1.
Oh, you are saying that it is delayed challenge.
Yes,
This is one thing.
Pura belated stage. And that already.
My jurisdictional issue can be, see, if the court doesn't have jurisdiction, doesn't have jurisdiction.
My lord, jurisdiction.
Delay will not help. Suppose you procure a conviction.
Yes.
Then after conviction, he'll say that
Any
court had
stage.
no jurisdiction. Then the entire conviction goes. Suppose he would not have moved the application. Ultimately, that court would have convicted. Then also in the application, take this stage.
It's a ground, but statutory.
Delay is not a ground for jurisdiction. But you tell me one thing in your counter, it is a very important thing, that the account is now transferred from Khordha to Bhubaneswar. So then initially the account was in Khordha. So therefore you might have chosen the jurisdiction of Khordha.
No. Initial is not at Khordha. Initial is Bhubaneswar.
That order.
When
the check was presented, that time where the bank was in Khordha or Bhubaneswar?
Check, it was a Bhubaneswar.
Page right.
Subsequently transfer. Now he's saying.
You tell me that is the only catch you have. Forget about the delay part. Delay part is neither here nor there. It is a jurisdictional issue. He can take it in the appellate stage also. Court having no jurisdiction can't try the case. As simple as that. You just tell me. Yes. What else you have?
Issued from Khordha. Now the case is.
There are few judgments also which may come to
my Lawrence senior has not served a copy to me till now.
Sir. My friend is appearing. All it in courts of the all it.
Supply the copy, and then counsel for the opposite party takes time to address the court on merit. Entry order to continue. So. You get some judgment also in this line.
No, he will never get it. Well, his account was at Bhubaneswar, check presented Bhubaneswar, check bounced Bhubaneswar, notice issued Bhubaneswar. Now, after these things was over, now he has transferred the account from Bhubaneswar to Khordha.
No.
Now he is claiming that because of the fact that the account is now operating in Khordha, it is maintained.
No,
because the cause of action arose is only on the day of presentation or subsequent ballot it was dishonored.
I have no objection.
And then, yeah,
ଆମେ ଯଦି ଖୋର୍ଦ୍ଧାରେ ବି ହବ କିଛି ଅସୁବିଧା ନାହିଁ କି ଭୁବନେଶ୍ୱର to lingering the process. The petitioner filed the petition.
What is the stage of the trial?
Trial is this is the stage.
Tell me this.
Already, my lord, examination, cross examination has already been done by the petitioner. And a complainant.
What is the take amount?
Already 10 lakhs.
Installment going there is no bonega.
10 lakhs.
If the cognizance will go, Paras, my friend, if the cognizance will go, how will you file a second application? Where will you file?
What wrong?
Limitation.
Complainant to file a case before the
Section 14 in he can get. Section 14 benefit he'll get.
Let him file whatever you want.
File it. Yes.
I'll give a copy.
Okay. Next.
93.
I may please your lordship.
Yes.
The petitioner challenges the rejection of 457.
No, last time you took time to for.
Yes, my lord. I am
memorizing your lordship. In
For
previous
example,
occasion, your lordship has directed what is the stage of the proceeding in lower court. That is JMFC Remal Devgad. I may permitted to draw your lordship attention the case of 1919, and now we are arriving at 2024. And so far cognizance, no cognizance has been taken by the Law and Trial Court. No PA has been submitted by the Forest Department. So in view of that, myself is a poor fellow. Depending upon there is no iota of evidence, they are not able to produce any valid and cogent evidence against me. On the other hand, they have seized the gun in question, which depends upon the life of to sustainable of the life of the petitioner. By engaging that by means of that firearm, he is earning and deputed in different localities by the nearby place and earn his livelihood.
Instruction,
now learn counsel.
My lord.
For that time to interception, these two matter on entry mode to continue.
As per
I have
instruction,
filed
I am
application of
appearing
interim
today, my lord, 2 weeks time for the.
Let's just.
No, I am the
I
petitioner,
am
my lord.
the opposite by.
I am the petitioner, my lord. As per instruction, I am appearing today. 2 weeks time for the filing of the agenda, my lord, and written note of submission.
Change of counsel.
Yes, ma'am.
Let's, the counsel is just there.
Yes,
just near to him. So there is no change of
Yes,
counsel per
Yes,
se.
instruction.
Irrespective of that, just point out 2-3 things, my lords. I have filed a vacation of interim. I have filed it 29/3/2023. Now our check amount is 55 lakh, my lords. On the last occasion, my lords was very grateful. My lords, I was grateful. My lords passed a very good order that we should go for mediation. They did not appear in mediation. They appeared on the first date. They did not appear in mediation. Now, my lord, sir, let me just come.
Let me finish the petition.
Let me just 1 minute. What I'm saying.
Give the opportunity for the petitioner.
A short date maybe.
Short date. He is giving a short date. We'll find out and give where matter can be heard.
Yes, ma'am.
We'll see.
to be taken, instruction not to be taken.
Till today, they have not submitted.
That is why he is sick only.
Yes, yes.
Just one. Lords passed a very reasonable order that you go for mediation.
I am for the petitioner.
Let him say what. Yes. See, what is his grievance is you are taken stay 1, 2, 3, 4, 5, 6, and 7 days.
Yes, my lord.
7 date of hearing. It starting from March 2023 to till today. The matter is.
As per my instruction, because I am appearing today, my lord. So,
You made a
Honorable High Court. Yes,
will
madam.
not change.
Yes, madam. Honorable Court directed to the this matter will settle in the mediation, my lord. Due to the petitioner's illness, the Goda Bhangi, my lord. Thereafter, he is not appearing, but he is not giving the time. I am agree for petitioner is agree. The Goda Bhangi is asking. Due to this reason.
What is the check amount?
Yes, 55 lakh, my lords. The 2 checks, 55 lakh. Only reason is I'm an MSME. That is only point.
No, you have moved application.
Mediation failure due to this.
143A. Have you moved?
Yes. And there is an order that has not been challenged. Only the cognizance order has been challenged.
I will file the rejoinder or 2 weeks time.
Lords, then counter 23.
No, then where is that 143?
Yes, my lords. They have filed in the, my lords may see the petition at page 17.
Have they paid that?
No.
70?
Page 17.
70?
17 of the petition. Now, the objections raised have been covered by the Supreme Court judgment now. It's on the point, straight on the point, and its objections have gone away. So that judgment will be placed. Yes, TRL cross scheme, lords. That judgment, that on the.
Mr. Das, you have a very difficult.
Yes, madam. Plus, I'm an MSME. That is also another.
55 lakh check. Listen, 55 lakh check. You came, there is an order of 143A
Yes, madam.
for depositing 3 lakh rupees.
Yes, madam.
You have not challenged, that has become final. You have not deposited that. You took a stay order 1 year back
Yes, madam.
and short time 7 times.
Your lordship.
And then because they were last time I have indicated that I'm not going to adjourn the matter.
Hello.
So therefore they have engaged you now.
Ma-
They
ma-
might
my lord,
not have
yes,
told you.
yes.
They might not have told you what was the intention. What was the observation made by me.
My lord, intention is, my lord, the present petition agree.
Subject to compliance of the 143 order, I am adjourned. You because you that has become final. You have to comply.
Because
You didn't challenge that order.
my lord, is I will take the instruction, my lord, due to the mediation fail, due to this reason, my lord. Only lingering of the case, they are not giving the opportunity. So I will take the instruction. Any next date, any week will that
No,
will
I am
fix.
giving you 1 month time, but subject to
Yes, madam, yes.
compliance of order dated
Yes,
23/11/2020.
yes, madam.
Yes.
I will take instruction.
Lords.
Right.
1 month.
Lords, one of those
the-
extensions, just one point, one of the extension given on 1,000 rupees deposit also. That has.
I know that.
That was
So,
also given, but.
all these thing might not have been informed to Mr. Das. So
Yes,
therefore,
ma'am.
he accepted the bill. Accepted
I have
the bill,
received a. But at the end moment, when I was going to say that this is not.
No, you are refusing.
I was refusing, yes.
See,
Again, these are
see,
the council is there, my lords.
These are commercial matters. You have issued the check.
Yes.
You are suffering an order of interim, order of 3 lakh rupees. You have not deposited. Despite that, the court gave indulgence because the court intended that it should be settled outside.
Yes.
And in mediation also, you have not cooperated for any reason. Like
Yes,
cocaine,
I have cooperated, my lord, due to they are not giving the time also. They audit time they found the
Who is not?
Mediation notice has gone.
That is not possible, madam.
Mediation report is there, my lords.
Mediation
So
they are absent.
if this is the way,
They are agreed
right,
to
then it will not be mediated.
Yes.
Anyway, right on. In the present petition, petitioner has challenged the cognizance order dated 13/1/2022 passed by JMFC Chandigarh in ICC case number 242 of 2021 under section 138 NI Act. 138 NI Act. The wide order dated 19/5/2023. Notice was issued to the opposite party, and an interim order staying the further proceeding was also passed. Thereafter, the matter was taken up for hearing on 28/11/2023, 8/12/23, 11/1/2024. 30th January 2024 and 29/2/2024. When the matter is taken up today, Mr. Sanjay Kumar Das, Land Council for the petitioners, seeks further 1 week time. In between, the parties were relegated to mediation. However, mediation has failed. Mediation has failed. Then counsel for the opposite party number 2 has moved an application seeking variation of the interim order dated 19/5/2020. Then counsel for the opposite party, where is that order? Interim order, opposite party pointed out, sir, that on 23/11/2022, the court below, while allowing the application under section 143 capital A of NI Act, as amended up to date, passed an order directing the present petitioner to deposit 3 lakh rupees. 3 lakh rupees. The said order was not assailed by the petitioner as yet and attained finality. Next paragraph. Subject to the compliance of order dated 23/11/2022, the present matter, the present petition is adjourned to adjourned to so and so. It is made clear that non-compliance of order dated 23/11/2022 will entail the petition of the present petition, entail the dismissal of the present petition.
Milots, I have only two claims, Milots. One, Milots, the LCR may be called. Why Milots? They have taken a ground on AC Narayan, with regard to affidavit on that.
The cognizance order, you want me to do a trial here?
No, Milots.
Simple.
Just look at the LCR, because that.
I am not asking.
Milots,
If you are relying upon anything, you file yourself.
Yes,
Not-
much better. That liberty may be granted.
Liberty is always there. Who stops you? Is there any injunction?
I will file because they
Is there any injunction?
I have pleadings are complete.
No, where have I checked? You can file anything.
Much obliged.
Who stops you? Yes.
Because I will
Give-
file the written note of
Written
some
note?
because counter.
Without reference to court. Dismiss without reference to court. Yes.
Much obliged, Milots. Much.
Yes.
Here, multiplicity of the prosecution is the subject matter of this petition. Admittedly, the petitioner and the informant both are of the same management of a private school. Informant with the charge of malad disputation, he was thrown away. Thereafter, malad, he has filed initially the affair. That is, malad, it pays 15.
It needs hearing. I'll fix it up because I will have to rise. Fix it up. Entry mode to continue.
97.
Day after tomorrow, man.
This is revision?
No, man. Yes.
Revision.
98.
My please, your lords.
Yes.
My lord, last
97 days they are going on adjourning the matter. Every day I am coming with preparation. Last में adjourn some
July, August. Geometry adjournment मांगते हैं July, August.
may please, your lords.
Every day people are mentioning take up the matter. People are in queue to get their matter listed. The matter which are listed, they are asking for time. Not coming. Yes.
May please, your lords. My lord, last occasion, your lordship directed to issue notice to the opposite party, but nobody has appeared before.
देखो service patient है. Despite notice served on opposite party number 2, nobody appears today. In the interest of justice.
Interim order is there.
Interim order to continue. Interim order is there?
Yes, my lord.
No, there is no interim order.
further proceed.
Yes, interim order to continue.
Obliged.
99.
May I please, my lord. But in this case, notice has issued the opinion of 2 minutes, but nobody has appeared. That is why the made sufficient.
Service is complete. Complete. Despite due service. No, despite service being affected on opposite party number 2, nobody appears. Nobody appears in the interest of justice. Urgent.
But I played for stay of proceedings. The petitioner, the uncle and aunt were they have proceeding under section 376. Other offences.
376.
They are the aunt and uncle, the mother and grandfather, and the
opposite party number 2 you have implemented.
Yes, madam. Notice and they made
but they are the victims.
And the victim is the
376, na? 376 2, and where is the question of staying?
No, they are the father and mother, they are the in-laws and all.
We'll see. Give a short minute. West side of the vacation. Yes, next. 100.
100.
100.
May please, your lordship.
Yes.
My lord, the matter needs some time for years.
Second week.
Your lordship, as your lordship is.
And I can't pull on further.
Aye.
All the revisions will remain.
Interim order there, my lord.
Interim order to continue. All revisions will remain. The 101 to 100.
170. 270. 270.
Clear.
Sorry.